Yes.
Yes, Your Lordship. I seek Your Lordship's indulgence in mentioning item number 3 of part 2, Your Lordship.
Item number
Item number 3 of part 2, Your Lordship.
3.
Yes, Your Lordship. I've
What
taken
you
the
want,
consent.
Miss Lalanpui, na?
Yes, Your Lordship. However, in this case, the learned respondent, she's Miss Caroline, she's on maternity leave. So if this matter may be
When
taken
do you
up,
want it?
Your Lordship, after the ensuing vacations.
But it's a 2012 matter. After January, you want.
Yes, Your Lordship, after the vacations, if possible.
Give a fixed date. Your MS Lalanpui, na?
Yes, Your Lordship. However, I'm.
I
Yes.
understand that. MS Lalanpui, Leonard Council informs the court that that the arguing counsel, MS Caroline, so and so is on maternity leave
Yes, Your Lordship.
and accordingly seeks an accommodation. Prayer is not opposed. Have you informed the other side?
Yes, Your Lordship.
Lordship, I'm the
You are
counsel
there?
for. Yes, yes.
So
Lordship.
then give his name. You are Mr. Jonathan
Johnny L. Tocho.
Johnny L.
Tocho.
L. Tochang, Leonard Counsel for the respondent. Sorry, for the petitioner. You're for the petitioner, right?
Lordship, yes.
So, Pranab, ticket respondent. Petitioner is present and does not oppose to the said prayer. Relist on such and such date.
15th January 26.
Much obliged, Your Lordship.
Yes, Mr. Das?
May I pray, Your Lordship? Lordship, in connection with item number 2 of today's list,
Yeah.
we had filed an interlocutory application for impleadment.
Yeah.
The IA has been numbered, but unfortunately it has not been listed
Can
today.
it be called?
Yes, Lordship. Can it be taken up today? Obliged, Lordship.
Yes, Your Lordship.
Yes.
I seek court indulgence in mentioning item number 4, part 2.
4.
Part
Yes,
two.
Ms. Fansiami, it's also an old matter. You want it when?
After vacation, Your Lordship.
You don't want me to take any hearing matters? All right. You're there for the other side, Mr.
I'm
Victor?
for the appellant.
Huh?
I am for the appellant.
You are for the appellant. Ms. Vansiami is for whom? For the respondent?
For the respondent, number 1 to 7.
Any objection?
No, my lord.
MS Vansami, Leonard Counsel, appearing for the respondent number 7.
1 to 7.
1 to 7 takes an accommodation which is not opposed by Mr. Victor L. Ralte, Leonard Counsel, appearing for the appellant. Relist on such and such date.
19th of January.
Deeply obliged.
Yes.
I seek your lordship indulgence in mentioning, even though it's part 1, my lord, I have a personal difficulty.
Wait, which one?
Part 1, item 19 to 21, my lord.
You're there
I'll
other
be
side.
This is a state appeal, my lord. The IA is for condoning a delay
Item
of.
number?
19 to 21, my lord.
Part 2.
Part 1, my lord.
Part
The
one.
reason for me mentioning is that, my lord, I am going for a checkup for tomorrow out of stage, my lord, and I have
But
to
this is
do.
there today, item 19 to
Yes.
21. These are condonation. We'll condone the delay then.
No, my lord, I have certain objections, my lord.
So we'll hear
need.
your objection.
No,
You
my
are
lord.
there.
No, my lord. The reason for me mentioning is that.
406 days, 427 days, and 433 days
Yes,
state
my lord.
appeal. We will see. You are there today. You are going tomorrow.
Yes, my lord. I have to do certain checkup
Packing.
again today, which I have brought tomorrow, my
I'll
lord.
take it up right now as the first item. Is that okay?
If your lordship can accommodate me for 1 week, my lord,
Huh?
after I'm coming back for after my medical
What is the
checkup.
ground of delay, Mr. Samuel?
My lord, the ground for delay, as specified in my application, my lord, is that the order was not communicated to the department, and it was through the council's letter that we came to know of the order, my lord. And henceforth, so all the communications for filing appeal was made, my lord.
So then, it
My lord,
appears
I
bona
have,
fide and
I have
sufficient.
certain
It's a
objections,
state
my lord, to
appeal.
that. And
What is there?
I want to have a complete
You have
hearing, my
nothing
lord.
to
If you're-
lose. I'm going to do it right now. You can go and do your checkups. I'll
No,
dictate
my
it
lord.
right
If
now.
your lordship permits,
I will hear you.
I want to have a full hearing.
I'm doing a full hearing.
No, my
you
lord.
Wait for a
I
minute.
mean,
Any more mention
when
is
I'm
there?
more medically fit, my lord.
No. You seem to be medically fit. I'm ready to hear. If you don't want it, that is a different thing. Otherwise, it would have taken another 5 minutes.
If your lordship can accommodate me for
Okay,
adjournment, my lord.
You would have got it. Anyway, now he doesn't want it. So heard Mr. Samuel, your appeal, na?
Yes, my lord, it's a state appeal.
As prayed for by Mr.
Lal biak no manam.
So and so learned counsel appearing for the respondents, real, which is not opposed by Mr. Samuel. So and so learned counsel appearing for the appellant, released on such and such date. Yes, next.
If we can have it next week, my lord, right, then we should be.
Ask your friend if he'll be back. He's on a medical leave from tomorrow. We don't know when he's coming back.
I'll be back by.
There's an execution has already been filed.
Mr. Samuel, I'm ready to condone it right now.
Yes, my lord.
I was asking your friend to be here for the next 5 minutes. I was in fact accommodating to take it as an item, the first item.
My
Also.
lord, if we don't get the stay, an execution petition is.
What
already
do you
been
want
filed,
me
my
to do, Mr. Samuel? I was ready
lord.
to
Release it
condone.
next week, my lord, by that time.
Give a date.
By
Thursday.
Friday, my lord. I'll be back by
This
Thursday.
Friday.
No, next Friday.
Next week, Thursday.
So he's coming next week, Friday.
Next week, Thursday, I'm coming back, my lord.
Thursday.
Yes.
All right, fix it on Friday.
5th of December.
Oblige, my lord.
Daily list for motion, item 1.
Yes, Mr. Lalram Zwaba. An eviction suit.
By this application, Lordship, the petitioners are assailing the validity and legality of the order and decree dated 26/2/2020, passed in eviction suit number 4 of 2019, along with the order dated 30/10/2025, passed in execution case number 52/2020.
So just 1 second. 1 second. Yes.
And seeking for declaration of such orders as a nullity
Anybody appearing
and
for the,
non-est in the eye of
You are
law
appearing?
on the ground of
For the state, my lord.
for the state?
It's a motion statement.
on the ground of fraud committed by the plaintiff respondent, number 5, for obtaining the said
You will
orders,
issue notice.
Lordship. And the order dated 30/10/2025, which was passed by the London Executing Court,
Where is that? Which page?
at page 116. 102, Your Lordship. Thirty-10, 2025. This is an order passed by the Civil Judge Senior Division in connection with execution case number 52 of 2020.
So this is an execution case. So
Yes, yes,
already direction is given for execution.
Yes,
So we will, Mr. Lalram Zawaba, it's very difficult. I suppose you are asking for a stay of this.
for stay, yes.
It will not be possible. Execution is already given. Civil court directions are there.
That's true, Your Lordship.
So you know how strict the apex court is in matters of eviction, executions.
May I take a Lordship to the
Yes.
judgment?
Right now, this land is whose?
Land is in our occupation.
Is by,
It is, the ownership has not been granted to us.
so who is occupying the land?
We are occupying the
You
land.
are occupying.
Occupying.
But it is, but you don't have ownership rights.
We don't have ownership.
And the civil court have said that you are not the owner,
But,
right?
Your Lordship, the fact is
And
that
against that, you filed an appeal.
we had filed an appeal, but it was barred by limitation. It was delayed. Because of delay, it was rejected.
I can keep the stay open, but I am not going to give it now. Otherwise, I'll reject it today.
Your Lordship,
I can fix it after 2 weeks, issue notice. We
if
shall
I
keep
take a
it.
Lordship to the judgment of the apex court in the case of 2007 for
Yes, give me
SCC,
that. Where do I find it?
it's there. 2007 for SCC.
Yes.
May I take a lordship to para 21 regarding fraud, your lordship. May I read the lordship?
Yes.
Now it is well settled principle of law that if any judgment or order is obtained by fraud, it cannot be said to be a judgment or order in law. Before 3 centuries, Chief Justice Edward Coke proclaimed, fraud
That's all
avoids
right.
all
It's a
judicial
nullity, but it has to be examined.
Yes,
We have not examined. If tomorrow after examination, we find that it is a nullity, then of course the consequences will
That is
follow.
true.
But
But at
right
this
now,
stage-
right now, the civil court's order stands. As per that
But-
civil court's order, execution is the only outcome, and you did not file an appeal on time. Your delay has condoned. Your delay is rejected.
that's true.
Against
because-
that, have you moved the apex court?
No, we have not moved the
So you have not taken further recourse against
And
that.
your lordship, may I take a lordship to para 39
Yes. Of which one?
of the same judgment?
Yes.
Once it reads, the above principle, however, is subject to exception of fraud. Once it is established that the order was obtained by a successful party by practicing or playing fraud, it is vitiated. Such order cannot be held legal, valid, or in consonance with law. It is non-existent and non-est and cannot be allowed to stand. This is a fundamental principle of law and needs no further elaboration. Therefore, it has been said that a judgment, decree, or order obtained by fraud has to be treated as a nullity, whether by the court of first instance or by the final court, and it has to be treated as non-est by every court, superior or inferior. And if I take a lordship to the previous paragraph,
Which is the order of the trial court?
order of the trial court is,
There was a RFA and there was a review petition also against that order.
yes, yes,
All dismissed.
all dismissed. Not on merit, your lordship, because of delay, because of lack of jurisdiction and all that. If I take a lordship to page 74, there's an order passed in eviction suit, 26/2/2020.
So there was the eviction suit was an ex parte order.
Parte order.
Against that also there was a
Against
CMA.
Against that, CMA was for the purpose of vacation of,
That is also
yes, that was also not entertained. And thereafter, appeal was filed, and even that was dismissed or rejected on the ground that the first appellate court, that
Alright.
is the court of district
where
judge.
where is the main eviction suit order? Page 74.
74, yes. The fact is that, your lordship, before reading this, I'd like to make a statement to the fact that the plaintiff is not the owner of the land. The plaintiff was earlier the owner of the land which was under occupation of the petitioners. But that portion of land was acquired for the purpose of widening of the road, which has not been utilized by the PWD. And in the meantime, since it was lying vacant, the petitioners, with the permission of the PWD, were occupying. And since the PWD were not having any objection to the occupation, they are even applying for allotment of the site, for house site. And your lordship, PWD, comment from the PWD was taken, and PWD said, since it is not encroaching upon the land, the road, we have no objection in allotting the sites to the petitioners. And the matter was under process in the revenue department. And in the meantime, the respondent number 5 was the plaintiff in the eviction suit. He came forward and then filed the suit.
Yes, yes.
And during the course of filing that eviction suit, he did not mention that the land did not belong to him. He all the time was claiming that the land belonged to him. But in fact, it was already sliced out from his LSC. A fresh LSC was issued to him in 2014. And in 2014 LSC, which was given to him, the land which is under occupation of the petitioners was not included any longer. In his earlier LSC, it was included. But this fact was not mentioned by the plaintiff. And as a result, thinking that he was the owner of the suit land, the eviction, the court, the Learned Trial Court, in connection with that eviction suit, had
But
passed the order.
now, the execution case, the scope is very limited.
I know. That's why, Your Lordship, since it is based upon fraud, Lordship,
You want to say that is why that's a nullity. There's no-
nullity.
That judgment is no good in the eye of law.
if I take Lordship again to para 22, para 22 of the judgment,
But here,
at
in,
page 231,
in this case, this is not a case of eviction. Is it a case of eviction?
no, it's not a case of eviction.
Yes.
It's a claim made by one party that he belongs, he is the owner of the suit property.
Are you holding any decision to say in eviction? If it is, this
No,
can be
here,
going, this
Lordship,
issue
if
can
I
go
take a
into.
Lordship to para 22, the matter will
There
be.
is one or two latest decision of the apex court for execution. These things cannot be gone into at this stage.
Your Lordship, if I take a Lordship to para 22, may I read, please?
Are you carrying those cases on eviction? Sorry, on execution?
Not on execution. But here, Lordship,
No, that I've understood. That's a settled proposition of law, Mr. Lalram Zawaba. But here we are already faced in a situation where you have not
that is
taken, you for your own actions.
we have tried all,
You've not been vigilant. You have been sitting over your rights, and ultimately delay has been condemnation of delay has been rejected.
that's true.
You have not taken.
And we have no other option
and
but
you-
to file
no,
the
you-
instant writ petition, Your
No,
Lordship.
you could have they gone into appeal against
But,
those.
Your Lordship,
You have not.
I,
Now,
my-
you
my-
are before.
I just take a
now
Lordship to
you are
para
before this
22.
court, and you want to stay the execution proceedings.
May I just take a Lordship to para
Execution
22?
court has already given the order.
That's true. That's why we have approached this honorable court by
But
way of
what
this
is
writ
wrong?
petition.
What is wrong?
Just, Your Lordship.
I am not
bear-
giving the stay. That I'm making it clear. I'll issue the notice.
Your Lordship, bear with
We
me.
will look into it. Let the other side come.
Yes, that's true. But in the meantime, if the execution process is not stayed, Your Lordship.
Sorry.
Be final.
Heard Mr. Lalram Zawaba, Leonard Senior Counsel, assisted by Mr. Stephen so-and-so. Also heard Mr. Samuel so-and-so, Leonard, you're appearing as an additional
Yes,
advocate
my
general. Leonard additional advocate general for the state, respondents number 1, 2, 3, 4. By way of this petition, and this is 226, 227.
226, yes. 226.
But maintainability now, because you have not come under,
That's why I'd like to read this para 22, Your Lordship.
you have not come under a revision.
No. Your Lordship.
Anyway,
it is-
we will look into all that later. This writ, by way of this writ petition under Article 226 of the Constitution of India, the petitioners are assailing the validity, legality of the order and decree dated 26/2/2020, passed in eviction suit number 4/2019, along with the order dated 30/10/2025, passed in execution case number 52/2020, arising out of eviction suit number 4/2019, seeking for declaration of such orders as a nullity and non-est in the eye of law on the ground of fraud committed by the plaintiff stroke respondent number 5 for obtaining the said orders. Stop. It is the specific case of the petitioners that they are homeless manual laborers earning their livelihood by chipping stones and selling it for the purpose of construction of houses, etc., and have been allowed to occupy the vacant lands lying on the side of the new capital complex, Chonpui Con
Does
Road, on temporary
complex-
basis since the year 2014. Stop. It is the further case of the petitioners that they have been occupying the subject sites by constructing temporary huts and thereafter Assam type buildings were also constructed and have been living there for the last 10 years. It appears that the site under the occupation alleged to be under the petitioners were earlier within the land of the plaintiff stroke respondent number 5, covered by LSC number 3194 of 1985. However, later on, a strip of land covered by the said LSC was acquired by the government of Mizoram for the purpose of construction and widening of the said new capital complex, Chonpui Con Road, way back in the year 2002. It appears that respondent number 5 was awarded. There is something missing in between your synopsis page 1 and 2.
No, Your Lordship.
How does 5 comes in the picture?
Plaintiff oblique respondent number 5. Plaintiff is the respondent number 5.
It appears that thereafter respondent number 5 was awarded compensation amounting to rupees 2,20,948 as cost of his land with an area of 4067.28 square feet. Thereafter, a modified LSC number AZL 3194/1985 in the year 2014, excluding the portion of land already acquired, was also issued to him. It is the specific case of the petitioners that they have been occupying the said acquired portion of land as However, the process of allotment of house passes was taken up by the Revenue Department since 2014, the same has not yet been finalized. Upon a complaint being filed by the respondent number 5, alleging that the petitioners have been illegally and without obtaining his permission has occupied his land, an eviction suit number 4 of 2019 was filed by the respondent number 5. Stop. In the aforesaid suit, the impugned order dated 30/10/2025 was passed by the passed. Eviction suit, the date is 26/2 or what?
26/2.
Sorry,
Yes.
the eviction suit, the prayers of the was allowed by the judgment and order dated 26/2/2020. Against the same, an execution case number 52 of 2020 was filed, wherein the judgment and order was passed by the executing court on 30/10/2025, situated thus the present revision petition, the present writ petition has been filed. Mr. Lalram Zwaba, learned so-and-so submits that the respondent number 5 has suppressed suppressed material facts and had obtained the judgment and decree dated 26/2/2020 in eviction suit number 4 2019, and hence such judgment and order is a nullity. In support of his aforesaid submission, he relies upon the decision of the apex court in the case of
A.V. Papaya Sastry,
A.V. Papaya Sastry and others versus Government of AP and others, reported in 2007, Volume 4, SSC 221. Issue notice, returnable 3 weeks. Mr. Samuel so-and-so accepts notice on behalf of respondent number 1 to 4. Extra copies within 3 days from today. Steps by registered post AD in respondent number 5. Heard the parties for, upon hearing the parties for consideration of grant of stay of the impugned order and decree dated 26/2/2020, as well as the order dated 30/10/2025 passed in execution case number 52 of 2020, comma, this court finds that the trial court in the eviction suit by judgment and order dated 26/2/2020 has prima facie elaborately considered the evidence on record and has recorded a clear finding that the plaintiff stroke respondent number 5 is the owner of LSE number AZL-3194 of 1985, which has been occupied by the respondents stroke petitioners illegally, and despite having been asked to vacate the same, they have refused to do so. It further appears that there is a clear finding recorded by the trial court that the respondents stroke petitioners number 1, 2, and 3 there's a clear finding that the petitioners are illegally encroaching and occupying the land of the respondent number 5, subject land of the respondent number 5. It further appears that despite knowledge of the eviction suit, the petitioners did not submit any written statement. It further appears that no appeal. It further appears that after this you file first an appeal, or you filed an
in fact, Your Lordship, we had engaged the council. We
no,
did not appear
I'm
on
not
behalf
on
of-
that. But what did you file?
We had filed an application for setting aside.
It further appears that though an application for setting aside the ex parte judgment and order dated so and so was filed, however, due to delay, the said application was rejected. Against that, though an appeal and a review was also filed, the same has also been delayed. Be that as it may, this court finds that this court does not find any reason to interfere with the to stay the impugned execution orders at this stage without hearing the respondent number 5.
Lordship, in the
Relist
meantime,
accordingly.
Status quo as on today may be.
Nothing.
Obliged.
For admission, item 2.
according rejected. Yes, Mr. Das.
Lordship, the
What is the
IA
IA?
Lordship, the IA is for impleading
Impleading whom? You're impleading,
the Deputy Director, Food and Drug Administration
impleading where in the writ petition?
in the writ petition, Lordship. and
You
this
want
one-
to implead the director.
Yes, Lordship. The Deputy Director and the Joint Director, Food and Drug Administration.
Where is the name appearing?
Lordship, it is in the cost title in the very front, Lordship. In fact, we had added them as parties, as opposite parties, but I have been informed by my learned counsel, by assisting counsel, that the registry has asked the names to be deleted.
Huh?
The registry has asked the particular respondents to be deleted for the time being.
Registry?
Yes, Lordship.
How can the registry
That is what
ask?
I was instructed,
Yes.
Lordship.
Which registrar have asked you to delete the name?
My lord, it was a junior who had filed, and he had informed me that during
Filing.
during the filing, the registry would not proceed if that respondent number 9 entered mention.
9. Who is 9? Where is the name?
The newly impleaded, my lord.
No, where is the name of the 9?
Lordship, in the very first page, Lordship, an application for impleasement of the Deputy Director, Food and Drug Administration, Director of Health Services, Government of Mizoram, Aizawl, and the Director.
Who is there? Who is the registrar filing? Call. Let us find out. Let's find out. And but I don't think, Mr. Malhotra, you have any objection
Your Worship, regarding this application,
in pleading.
in fact, Your Worship, the respondent number 3 in the present writ petition is the person they are trying to impede in this interim application.
3 is the joint director,
Yes, Your
controlling and licensing authority director of health.
Yes, join the,
And this is, Mr. Das, this is again you want the deputy director
Deputy Director, Lordship.
and the joint director.
joint director is
Joint
already a
Director, Food and
party.
Drug Administration, we can skip, Lordship, but the Deputy Director will be essential. Why, Lordship, may I point out? Lordship, after filing of the writ petition, when the affidavit in
No,
opposition.
but tell me one thing. The joint director, Food and Drug Administration, Director of Health Service, Government of Mizoram, Aizawl,
Yes, Lord.
is he not the same person? Number 3, the
They have
joint
already-
director,
have already
FND,
briefed them.
controlling and licensing. Please have a look at your
Yes, Lordship.
arrayed respondent at page
Yes,
2,
Lordship.
Mr. Das.
Yes,
He's the
Lordship,
same
absolutely.
person, then why do you want to implead him again?
I'm sorry, Lordship, regarding respondent number 10, but Lordship, the Deputy Director will be essential, Lordship.
No, so you see, the registry must have correctly. You may have made him double parties, and they may have said delete him.
I am not aware, Lordship, because of the filing.
No, but then you are moving the application. It is at your request. The application has been called,
Lordship, but the
despite
Deputy.
the same not being in the list.
Lordship-
You are expected to read your application.
Done, Lordship. I'm sorry, Lordship.
Yes.
The Deputy Director, Drug and Administration, Directorate of Health Service, he is not a particular.
That's all right. That we've
I'm
understood.
sorry about the respondent number 10,
In
Lordship.
fact, Your Worship, my humble submission at this stage is the joint director can very well represent the
Mr.
deputy director.
Malhotra, more the merrier.
I understand, Your Worship, but the Your Worship is delaying the matter. They have a stay order in their favor since January.
They have a stay in their favor.
That is
Very
why
well,
you-
we will implead them, and I'm sure who is appearing for the respondent number 3, Mr. Victor?
No, my lord, I am appearing for investment number 8.
Ms. Vansami, you are appearing?
Yes,
So-
Your
So you will take note, we will appear, we will issue the notice today only,
Yes, Lordship.
and then
In fact,
she'll
Your Worship,
file.
In fact, Your Worship, in that case, if my learned friend wants to impede the deputy director, we have no objection. If Your Worship will issue notice again, another 2-3 months will go. Let the application be allowed.
No, I am not giving the, I am sure Ms. Vansami, you don't need 2-3 months to write any affidavit for the deputy director because the stand taken by R3 will cover the deputy director as well, right? So have you already filed your return for R3?
Yes, Your
You file. So you just check if that is the same thing. If it is the same thing, you make that submission on the next date. And if something has to be added, you file a short affidavit. I don't think that the deputy director and the joint directors will file separate affidavit. He wants to bring it. We will not stop him today. But nonetheless, keeping in mind that there is a stay operating against the respondents, we shall make that clear. That on this ground, we shall not be entertaining more accommodation in this matter. Okay?
Yes, Your lord.
Yes, Mr. M. Das, Learned Counsel, MK or M?
M.
M. Das, learned counsel, appearing for the applicant. Stop. Also heard Mr. A.R. Malhotra, learned counsel, appearing for the respondent numbers. Sir?
7.
7. And Mr. Victor L. Ralte, learned counsel, appearing for respondent numbers. 8. And M.S. Swansami, learned counsel, appearing for respondent numbers 1, 2, 3, and 4. Na?
1 to 6.
1 to 6. 1 to 6. By way of this application, comma, the applicant is seeking impleadment of the Deputy Director, Food and Drug Administration, Directorate of Health Services, Government of Mizoram, Aizawl, and the Joint Director, Food and Drug Administration, Directorate of Health and Services, Government of Mizoram, Aizawl, as respondent numbers 9 and 10. Pertinent that the Joint Director, FND, Controlling and License, FND, Director of Health Services, Aizawl, Mizoram, is already arrayed respondent as respondent number 3 in the connected writ petition. Hence, Mr. M. Das, learned counsel, fairly submits that due to an inadvertent error, the respondent has been sought to be arrayed again as a respondent and accordingly does not press the said prayer in respect of respondent number 10, in respect of proposing arraignment of respondent number 10. Okay? It appears that the applicant is being aggrieved by the manner in which valid highest bid of the applicant submitted by her in the tender process initiated by the respondent authorities for running the pharmacy canteen in the Zoram Medical College SRHF for a period of 2 years was rejected. And the respondent number 7 was appointed to run the same. It appears that after the returns have been submitted by the respondent number 7, the presence of the Deputy Director, Food and Drug Administration Director so-and-so appears to be essential and necessary for proper and effective adjudication of the writ proceeding. In view of the aforesaid stand taken in the affidavit and having heard the learned counsels appearing for the parties, this court deems appropriate to implead the Deputy Director, Food and Drug Administration, Directorate of Health and Family Welfare as newly impleaded respondent number 9 in the writ proceedings. Let an amended cause title be submitted within the course of the day. Within the course of the day. You don't submit it, it will get, the order will get vacated.
During the course of the day.
And then, where is the main case? I disposed of.
Lordship, the main case, I would like to make a submission, Lordship. Lordship, what has happened is, in the affidavit in reply, which we have filed, Lordship, some clerical error, Lordship, 2 pages could not, got left behind. So,
Huh?
2
What?
pages of the annexures, they could not be annexed to the affidavit in reply. So, Lordship, I have already prepared the additional affidavit. Can I be granted the leave to file?
How that can be?
Lordship, I will show you, Lordship, if required.
No, I'm not entertaining that affidavit of yours. In that case, you'll have to come by way of an amendment or an application. What additional affidavit?
I would not like to delay the matter, Lordship.
No, very well. You see, procedures are procedures. Now, if some 2 pages have been, Mr. Das,
I'm sorry.
you filed your additional affidavit. If they don't object, very well, it will be taken on record. But this court is not giving you any liberties to file anything.
Lordship.
You want to file it, you file it.
Lordship.
Isn't it, Mr. Malhotra? You have a look at it.
Yes. Yes.
In the main case,
Your Worship, in the main case, Your Worship, we have just received the affidavit in reply to the affidavit filed by the respondent number 7. And Your Worship, we would like to make certain clarifications
You
to
do.
the affidavit filed
You
by
do.
them. So if permission may be granted to file an affidavit.
I'll allow you because you file whatever. Then I will say let all parties are at liberty to file necessary additional affidavits as required.
Yes.
And I'll also ensure that for the newly implemented respondent 10, if anything is to. I think that should be yes, Mr. Victor.
My lord,
But this
I
petition
had-
is yours petition. The petition is by you or who's filed the petition?
The petition I
You have filed. Yes.
I had recently entered appearance on behalf of respondent number 8. I have not been served copy of the affidavit by any of the parties,
Which one?
by the state affidavit and R7 affidavit.
Yes, why are you not giving it?
I have
This is
recently
the first time he
entered.
has appeared.
I have asked,
Mr. Victor, I don't think you need to obtain such orders from the court. Mr. Malhotra and Mr. And Banjami are your colleagues, senior colleagues. Mr. Malhotra, you just tell him, he'll give it to you.
Your Worship, this matter was filed in January. My learned friend has entered appearance for respondent 8 at the fag end of the year. We'll do it.
All
We'll
right,
do
you
it.
give it to him.
Surely we'll do it.
Mr. Victor, they'll give it to you. I don't think I'm going to give that direction in the order. I'm sure they will give. Heard Mr. Hey, ওপৰৰখিনি সব একেই থাকে। ইয়াত তুমি newly impleted to কৰি দিবা, huh?
Respondent 9, not 10.
9,
Completed
sorry.
9.
Newly impleted 9, huh? So she is from 1 to 6 and 9, correct? 1 to 6 and 9. 7 is Mr. Malhotra, 8 is Mr. Victor, right? And in view of in view of the order passed in the IA so and so, impleading the respondent number 9 as a newly arrayed respondent in this proceedings, let notice be issued so and so, making it returnable on such and such date. Give a date, please. After 2 weeks. 2 weeks is sufficient for you all to take whatever you want to do.
11th of December.
So and so. It's open. 11th is open.
Yes, Your
It's all right. Go on. Principal bench is not closing, Mr. Das. Principal bench is not closing. You will have no difficulty in coming.
No difficulty.
And that in the meantime, parties are at liberty to file additional affidavits if so advised. Needless to be clarified that the newly impleaded respondent, if so advised, shall file return in the matter by the next date of listing. Stay is operating till today. Any stay granted earlier shall continue till the next date of listing. And needless to be further clarified that pleadings filed or going to be filed shall be served on learned counsels appearing for all the parties. Yes. One second, Mr. Das, and where's your junior counsel? This petition, they have filed this including the director and joint director. Now they are saying that the registry have told them that if you include them, then they will not allow the petition. Finally, they remove them. Now they have filed, but I find the joint director is already there. The deputy director is not there. See, it is already there. Right? This one is not there. So today I allowed it.
The finance is required to comply with the order of this honorable court. And the secretary to the government of Mizoram Finance Department has been made a party.
This is a contempt petition.
Yes, my lord.
Some compliance was supposed to give Ms. Mary.
Your Lordship, whoever I represent, the concerned authorities that I have represent have already taken steps on their part. Now, it is on the finance department to take an action
The sanction.
for the sanction.
Who is appearing for the finance department?
No,
None, my
none,
lord.
Huh?
none appears.
None appears.
Yes,
They have been issued notice.
notice is issued.
So
notice.
then direct personal appearance.
Yes, my lord, that personal appearance is directed.
Your Lordship, if I may be given a chance to inform them,
Tomorrow, not tomorrow, Thursday, I'm keeping it.
Thursday, okay.
You inform them.
Yes, I will
Thursday,
inform them.
if there is no one for the finance, then this court is going to call them. If required, I will take appropriate steps to ensure
Yes.
the attendance of the officer in the court. Please inform, huh? Today, anyway, should say, I heard Mr. Zoram Sana, learned counsel appearing for the petitioner, stop. Also heard Ms. Mary L. Kingtail, learned counsel appearing for the contemner stroke respondents. It appears that there is no appearance on behalf of the respondent number 7. Within bracket Didiba. Who is 7?
Secretary to the Government of Mizoram Finance Department.
It is asylum, huh? So and so. It appears that it appears from the last order passed by this court on 26/9/2025 that the sanction of the finance department is required to fully comply with the order of this court. However, in view of no representation on behalf of the respondent stroke contemner number so and so, the matter could not progress further today. Ms. Mary so and so, in her usual fairness, have submitted that she may be given an opportunity to inform the said officer, as the said officer is also is a government employee. In view of the aforesaid, relist on such and such date, Thursday. It is needless to be clarified on the next date of listing, if there is no representation on behalf of the so and so, the necessary orders to secure the personal attendance of the said officer shall be issued by this court.
27 November. Item 4.
My lord, I appear for the
Yes.
petitioner, my lord. My lord, as per last order, my lord, in this CRP, my lord, CRP number 11, in total there are 10 respondents, my lord. 1 to 9 are private respondents and 10
Mr.
is the state
Khera,
respondent.
this is what, a civil revision petition.
My lord,
But I think service is still awaiting for respondent number 3, 7 and 9.
my lord, I was coming to that only, my lord.
So I
Just
think
giving-
then we need not waste more judicial time of the court. Let
My lord.
me pass the necessary orders for today.
My lord.
Heard Mr. N. Khera, learned counsel appearing for the petitioner. Also heard MS.
Miss Rosie,
Rosie, learned counsel appearing for respondent number
1, 5, 6, and 8, my lord.
1, 5, 6 and 8.
my
And
lord.
MS Lalan Pui, learned counsel appearing for respondent numbers
10, your lordship.
10. It appears from the office note dated 21/11/2025 that service in respect of respondent numbers 3, 7 and 9 are still await service, relist after 2 weeks on a date to be fixed by the registry.
My lord, interim order may continue.
Interim, if any, shall continue till the next date of listing. Yes, Mr. Khera.
My lord, on the 16th of December, if it can be. listed,
All
my
right,
lord.
16th December. Ms. Rosie, Ms. Lalan Pui?
Yes, your lordship. 16.
I am told, Mr. Khera, that 16th is a holiday here.
16.
My lord, 17th December.
No, I think the winter holiday starts from?
The last
15th.
working days, yes.
From 15. Here, the winter break starts from 15. I
12th.
think the last working day is on 12th.
Yes, your lordship.
And then
My lord.
the courts reopen only in January after,
My lord,
12th?
it can be listed on the 12th of December.
when?
12th of December.
The last
Or-
working day. Ms. Rosie
11th,
and Mrs.
11th, my
Lalanpuri?
lord. 11th, my lord.
All right, 12th. 12th.
My lord.
Item 5.
Just an item 5.
My lord, there are 2 respondents.
You're
in
you're
total.
again here also, but Mr. Lalfaghzwala, you are for whom? I think. And
Private
2,
respondent.
who's for 2?
Yes, your lordship.
You were supposed to file a counter.
Yes, Your Lordship. I have not received any information as such. The only
So you
information that
want
I-
further time?
Yes, Lordship. If at least 2 weeks time may be granted.
2 weeks'
Lordship.
time. All right. Heard Mr. N. Khera, learned counsel appearing for the petitioner. Also heard Mr. Lal Fagswala, learned counsel appearing for respondent number 1, and MS Lalan Pui, learned counsel appearing for respondent number 2. As prayed for by MS Lalan Pui, learned counsel appearing for respondent number 2, relist after so and so to enable the respondent file return in the matter.
My
12th
lord,
of
interim
December.
order may continue.
Interim, if any, shall continue till the next date of listing. I'm fixing this also on the 12th.
My lord.
Item 6.
My lord,
Counter by whom, Mr. Khera? Nobody
My
is
lord,
filed.
My lord, we have filed, I'm here for the respondent 1 to 10, and we have filed our affidavit in opposition, my lord.
Today,
No,
you have filed.
yes,
we have
my lord,
received it, my lord. We have, state has not filed as yet here also.
Yes,
Your Lordship, similar prayer. 2 weeks time may be
2
granted.
weeks, all right. And do you want to file any reply to that?
My lord, we will file, we are only awaiting for the state to file.
All
so
right,
we
all right. Heard Mr. Nitin Khera, learned counsel appearing for the petitioner. Also heard MS Rosie so-and-so, learned counsel appearing for respondent numbers
1 to 10, my
1
lord.
to 10, and remaining respondent MS Lalan Pui so-and-so. As prayed for by MS Lalan Pui, relist on such and such date to enable the state file return in the matter. In the meantime, if the petitioner is so advised, shall file reply affidavit to the affidavit in opposition, file on behalf of the respondent numbers 1 to 10. Interim is there?
My lord.
Interim, if any, shall continue till the next date of listing.
My lord, 12, 12, 25?
Huh?
The same 12?
Yes, yes.
12.
Item 7.
This is also, how many more matters you have?
My lord, I have until
Huh?
16, my lord.
16
Until-
matters.
I-
So in
No,
all
up till
16
item-
matters, the same
12.
orders or?
No, my lord, they will command different orders, my lord, because somewhere the service
Okay,
is
okay,
completed.
now we are taking up item number?
7.
7, yes. Here I think service for 1, 3, 9, 10, 23, 34, 39, 42 and 43 is awaiting.
Yes.
Await service in respect of respondent numbers 1, 3, 9, 10, 23, 34, 39, 42 and 43 are relist on 12 so and so. Next.
My lord,
Item eight.
interim order may continue, my
Interim,
lord.
if any, shall continue till the next date of listing. Yes, item number 8, assessment and execution.
My lord,
Yes,
item number 8, 1 to 5 are represented, my lord, the private respondents, and they have filed their affidavit. Respondent number 6 has the state, we are still awaiting an affidavit from
yes,
them.
Ms. Lalanpui?
Yes, Your Lordship.
Okay,
Similar
it would,
prayer.
first Lalanpui state respondent, as prayed so and so, relist 12, enable affidavit.
My lord,
Interim,
interim
if
order may
any-
continue.
Yes, yes,
Item 9.
Oblige, my lord.
yes. Counter, Mrs. Lalanpui, and who is there? Mr. Alfaxwala. Have you
My lord,
filed?
state, private respondent have filed their
Okay,
affidavit.
same,
State-
Lalanpui, 2 weeks, 12. Interim.
Item 10.
Await service in respect of respondent numbers 2, 6, 8, 9, 10, 11, 16, 19, 21, 25, 26, 29, 32, 34, 36, 37, 38, 39, 43 and 44. Repost on 12. Next.
11.
My lord, interim may continue.
Yes, yes. Item 11, no, respondent number 2 and 5, any representation now?
My lord, not to our
Anybody
knowledge. my lord.
appearing? Last time also there was no representation. What about, you filed your counter, Mr. Counsel, R6?
I have 5.
My lord, we
What
have-
about
R1,
state?
My lord, R1 has filed, we have received, state has not filed, my lord.
State, Ms. Lalanpui, you're not there?
My lord, the learned additional advocate.
Slowly,
general-
slowly. Are you there or not here?
Your Lordship, I'll be on behalf of the learned AAG.
But the AG, I don't see he is here.
Yes, Your Lordship. So, AAG.
Samuel?
Yes, Your
Yeah, he's there, right behind you. Yes, counter?
Apologies, my lord. My lord, I've received the comments
Apologies for what?
entering late.
Oh, that's all right. Yes.
My lord, although we've received the comments, there's hardly anything to file as,
You're not filing.
so we'll not be filing, my lord, because the assessment was made as per the direction of the order, my lord.
No, as per the direction of whose order?
The
Fast track.
fast track court judgment and order, my lord.
Are you sure you're not going to file anything?
That is the only thing I've received.
So I'll record that.
Yes, ma'am.
And what about R2 and 5? They are not appearing till now. So I will record the submission of Mr. Samuel and fix it on 12 only.
My lord.
Heard Mr. N. Khera, Learned Counsel, appearing for the petitioner. Also heard Mr. Yes, your name?
Nelson Liana Kiang.
So and so, Learned Counsel, appearing for respondent number 6, na? 6,
One, my
right?
lord.
1.
6 is state.
Okay, 1 and and Mr. Samuel so and so, Learned Counsel, appearing for the respondent number 6. None appears for respondent number 225 on call. It appears that no, Mr. Samuel so and so, Learned Additional Advocate General for the state submits that he has received, though he has that no affidavits shall be filed on behalf of the state respondent in the matter. In the meantime, if the petitioner desires, if so advised, shall file reply affidavit to the counter affidavit filed on behalf of the respondent number 1. Repost on such and such date. Interim, if
interim
any,
may
shall continue. Yes.
My lord.
Item 12.
Yes. Await service in respect of 1, 2, 4, 5, 6, 8, 10, 11, 12, 13, 29, 31, 32, 33, and 36. Interim, continue.
13.
Repost on the same date. Huh? Counter, yes.
My lord.
13.
I think you have filed yours.
my lord.
And Mr. Samuel? Same?
Submission is the same, ma'am.
Same. We are according to order. Exactly same order, Didiba.
My lord, here
Samuel
we were-
has not filed. And against R1, if they want to file. And post it on an interim. Yes. The same order
lord-
I have given. Huh?
My lord, this is item 12, my lord.
Yes, item 13. Item 12 service is yet to complete. Item 13.
My lord, item 12, we had taken steps on respondent number 26 yet again. That may be reflected. As per last order, we were required to take steps.
26, I have not, all right, in item 26 further, sir, it appears that steps in
Item
respect
12, my
of
lord.
R20's respondent number 26 as directed by this court has been taken in the meantime. All right.
My lord.
Item 13, the same order. Mr. State is not filing. So same order and you are at liberty to file the reply if you so advised.
My lord, item 10 also, the submission of Mr. Samuel may be the same because
Yes, I have given.
item 10.
Item?
10 to 10 to
Correct, I
13.
have already told.
My lord.
I understood.
Item 14.
Yes. Sorry if I am going fast.
My lord.
But I have taken care of everything.
My lord.
Yes. Item 14. Yes,
My
respondent
lord,
number 2.
we were required to take fresh steps.
R1.
R1, we had taken that, my lord. However, service is awaited.
It appears that fresh steps against respondent number 1 has been taken as per the last court's order. However, the same is awaiting repost on 12th. Yes.
My lord,
Item 15.
Interim is there.
My lord.
All right. Interim if there, continue. Yes.
Item 15.
15 again, 2 and 3 service.
My lord,
R1
one
has
has been
filed.
served,
Huh?
but one has been served but unrepresented. Service report awaited on 2 and 3. 4 is the state, my lord.
When you say Ankhera and Samuel for state respondent, no representation on behalf of R1, await service in respect of R2 and 3. Interim, if any, continue, repost on 12.
Item 16.
R1,
My lord, R1 service is awaited.
AD card for R2, I think, is received back.
My lord, but no, they have not appeared. No
R2,
representation.
who is R2? Is a state?
No, my lord, R3 is state. R1 and 2 are private respondents.
Okay, Mr. Khera for petitioner, Samuel Additional Advocate General for R3, state respondent. It appears that though service is complete in respect of respondent number 2, however, there is no representation on call. Await service in respect of R1 repost so and so interim, if any, till the next date.
Highly
Item
obliged.
17.
My lord, permitted to leave?
I think your matters are over, Mr. Khera.
Over, my lord. Obliged, my lord.
Yes, 17. Yes.
Please, Your Lordship, this is an RFA against the impugned judgment and order dated 30th
Mr.
11
Ricky, I have not
2024.
seen you for a long time on my last 2 visits, I think.
Yes, my lord.
Yes.
My lord, this is an RFA against the impugned judgment and order 30th 11 2024 and degree dated 9/12/2024 passed by the learned trial court civil judge. Senior
Why is
Division.
it there today? It is listed today for what? Or notice and all have been issued or not
Yes, my
issued?
lord. Notice has been issued. It is IA.
There is an IA.
Yes.
What is the IA for?
IA is for the stay, my lord.
And
And
no one is
previously,
appealing.
IA has been disposed, my lord. That is for the condonation with the order dated 11/11/2025.
No, right now the IA that you are pressing is the IA 89 of 2025.
Yes, my lord.
And notice issued
Yes,
in
ma'am.
the IA? I don't think so.
No, my lord. It has not been issued.
Notice is not issued. Notice is not issued. I think we'll issue notice then. No,
Yes, Your Lordship.
notice has to go.
Yes, Your Lordship.
Okay.
My lord,
It's a declaratory suit. Your declaration has been made in favor of the private respondent
yes, my lord.
in regarding land certificates.
Regarding, yes, my lord.
What
Periodic
is it
pata.
called? LS.
Periodic pata, my lord.
No, what is that other?
LSC.
LSC. So we'll have to wait. We cannot grant you a stay without hearing the R2. 2 weeks,
My lord, 2 weeks.
3 weeks.
2 weeks will suffice, Your Lordship.
You will not be able to serve it within a week's time. So 2 weeks it will take.
My lord, this
Then
is,
in any case, you come with condonation, Mr. Ricky.
my lord,
That-
it has been condoned.
Correct. So had you come without a condemnation, I could have also thought about the stay prayer. But now, see, court has already shown liberal to you. We've condoned it. You'll have to wait for some more time before you get a stay. Heard Mr. Ricky, J.H. Ricky Lalrutfela, right?
Fella. Yes, my lord.
Learned counsel appearing for the applicant. Also heard Mr.
Johnny L.
Johnny L.
Tauchong.
Tongchong, learned counsel appearing for respondent number 1, and MS Vansami, learned counsel appearing for the state respondent number 2. So all respondents, no, 3 is not there, no?
There's no respondent 3, my lord.
So there are just 2 respondents.
Yes, my lord.
So who is the private respondent?
I'm the private respondent.
You are
Lordship.
already
R1.
appearing. Oh, I thought. Then let me see the stay order.
Yes, my lord.
I thought there was no representation. What is the ground of challenge, Mr. Ricky?
My lord, if the grounds of challenge is that there is no evidence which could satisfy the learned trial court as to whether the appellant herein has encroached the respondent number 1, since the learned trial court has only received and relied on the duty report of the surveyor. And that surveyor report, my lord, in the trial court has passed an order dated,
Mr. Johnny, you are opposing the stay?
Lordship, I'm not strongly opposed. However, Lordship, the landed property is the only land which having by the private respondent, Lordship. If my learned friend is not pressing to enter into the landed property, I'm not opposing, Lordship.
my lord, there is, we haven't mentioned anything regarding that in our prayer. So we have no issue regarding that. We just have to, regarding the stay, that is the decree, in making some modification as per the periodic pata. That is, the surveyor duty report has mentioned that there is the clerical mistake, which is very beyond the order that the surveyor report has made that there should be some correction in the periodic pata of the respondent. So that is beyond the order given by the trial court, my lord.
Beyond the jurisdiction.
Yes, my lord.
He has done something beyond what has been granted.
Yes, my lord.
First, you take one by one to that, because if I have to grant the stay, I'll have to
My
go
lord.
into these details.
Yes, my lord.
Yes. Where is it?
My lord,
Show me
if
the,
I may take you to page number 97.
Ms. Ansami, you probably will not have much to, because it's a private 90?
97, my lord. Of my main petition, my lord, of my main RFA,
Oh, not the IA.
not the IA, my lord.
No, I have the RFA. 97.
Yes, my lord.
Yes, detailment order.
Yes, my lord. In this detailment order, as if I may read out, my lord, as per the order, so and so, if I may read out from the third sentence, my lord,
Yes.
it is to conduct spot verification on 21st November 2022 to ascertain the location and boundaries of the land covered by periodic patta number 437 of 2006 located at so and so. Here, it is only written that it is to ascertain the location and boundaries of the land covered by the periodic patta number 437 of 2006 located at Rengtekon Parimwal Marlam Chiamwal 9 km Marlam belonging to Pilusi Lalding Heti, who is the appellant herein, my lord. And that of periodic patta 515-2008 belonging to Pu Lalrin Moyeran Clay, that is the private respondent.
Number?
Number 1.
Yes.
He must also clarify whether these lands overlap with each other and the extent thereof, my lord.
Yes.
So that is the only order given to the surveyor. But the surveyor duty report has mentioned such that there is some clerical mistake, so and so.
Where is that?
There is the duty report from the page number 90A. There is
90?
the English 90 alphabet A.
Yes.
There is the
The
English translation, my lord.
translated copy.
Yes, my lord. It is quite lengthy if I may read out from.
90 capital A.
Yes, no. Small letter A.
Okay. Yes.
It is quite lengthy, my lord, if I may read out.
Yes,
the-
you read the relevant part. Where? From where?
From this
Page
the-
90 or
page
91?
90, my lord.
Yes.
It will make much sense if I may read out from here.
Yes. From the bottom or from the top?
From the
Which line?
second paragraph, my lord.
Second paragraph. It starts with the
These
northern
four
boundary.
individuals.
Huh?
These 4 individuals. Your lordship has it?
I'm not getting it. 4 individuals. Oh, yes. Yes, I've got it.
Yes, my lord. If I may.
This 4, yes, you may.
These 4 individuals visited the location and examined the land and related documents. Upon inspection, it was found that P. Pata number so and so 2006. That is the periodic pata of the appellant, my lord.
Yes.
Originally issued in the name of Vanlal Rema, son of P.C. Lalming Liana of Project Veng Kolosip, was transferred to Lucy Lalding Heti, who is the appellant, daughter of Lian Chungnunga of Vengthar Kolosip, and P. Pata number so-and-so of 2008 was issued to Sri Larin Moya, Rentlei, son of Thangfala of Bilkotlir, falls within the same location. Upon location verification, it appeared that Lucy Lalding Heti's P. Pata location was approximately 9 km from Harimwal. However, the 9 km post could not be identified. The northern boundary of the land is stated as H. Lalram Luna, and that there is no confirmation of who this person is, nor is there clarity on whether the land belongs to H. Lalram Luna. Furthermore, as the land falls under Bilkotlir South jurisdiction, after the division of Bilkotlir North and South VC, the no objection certificate should have been issued by the Bilkotlir VC president with a signature and seal. However, it was instead signed by Kapranga VCP Kolosip VC2, which is improper. Additionally, the NOC does not include the date, names of affected individuals, or their father's name, making it incomplete. Therefore, P. Pata number so-and-so of 2006 should be issued by the Revenue Department with the signature and seal of the concerned VCP to be valid. Similarly, P. Pata number so-and-so of 2008 issued to Ms. Sri Larin Moyer and claim mentions the location as AS Road, 18 km between 2 culverts. However, this appears to be a spelling mistake as 18 kilometers from Kolosip falls within Bilkotil town near Kualmoy Veng UPC Northeast India Church, where land allotment under P Pata is not possible. Additionally, Sri Larin Moyer Rentle is looking after and occupying the land and has cultivated approximately 6,000 betel nut trees. A portion of the plantation are fully matured, while some portion of the plantation did not attain maturity. Given this situation, it is believed to say that Sri Vanlarima Lucy Lading Heti are not actively utilizing the land. Upon further verification, these two P Pata documents indicates that if it falls on the same location, although the location as recorded in the document of both parties may differ, both the landowners,
What do you want to show from here?
with
Because
what,
ultimately you want stay of the judgment and degree dated 30
yes, my
11
lord,
24.
the trial court has totally relied on this spot verification.
So
That is,
according to you, this spot verification has exceeded the scope of inquiry given by the
Trial
by the detailment order.
yes, my lord.
That is your submission.
That is my submission. And
And
impugned
how has it
judgment and order,
affected you? Yes, what which
impugned
part of
judgment and
the
order,
impugned judgment that is affecting you?
yes, my lord, if I may take you to page 84 of my RFA.
Yes. Yes.
From, if I may read out from para, number 2, para 2.
Yes.
This suit coming on this day, the 29th day of November 2024, for final disposal before the court of the learned senior civil judge in the presence of Joseph L. Pachua, others learned advocates for the applicant, and Johnny So and So, Johnny L. Tochong advocates for the defendant number 1 and Andy for the defendant. It is decreed as follows. Plaintiff's suit is dismissed. The court claimant's defendant's suit is decreed on merit. The defendant counterclaimant is declared as the legal owner of the landed property covered by P Pata number so and so of 2008, situated at AS Road 8 km Bulkor Lekor in Kar. The plaintiff's periodic Pata so and so of 2006, located at Rengtik Klang, Parimwal, Marlam, so and so is declared null and void. The defendant number 2 shall make necessary changes in the P Pata of defendant counterclaimant to reflect the location as in point. So from this, my lord, it is clearly
You are the plaintiff.
yes, my lord, in the trial court.
So your plaintiff so and so is declared as null.
Yes.
That part you are aggrieved.
Yes, my lord. As well as that the defendant number 2, who is the state,
Shall make necessary changes. So that's these two part.
Yes, my lord.
So this does not affect the your rights, isn't it?
Yes.
Okay. Heard, Mr. Take the IA, huh? In the main, you main to pisot notice kori diba. I don't think notice is issued in the RFA, na?
Yes, Your Lordship, in the RFA.
In the RFA, you issue notice, huh? And make it returnable 3 weeks. And the IA take it for disposal. And the names to me, itama duty to me gompai jaba. Heard Mr. Ricky so and so, learned counsel appearing for the applicant. Also heard Mr. Johnny so and so, learned counsel appearing for the respondent number 1, and MS Panzami, learned counsel appearing for the respondent number 2. By way of this application, and by way of this application, the applicant is seeking stay of the operation of the impugned judgment and order dated 30/11/2024 and decree dated 9/12/2024 passed by the Learned Civil Court Senior Division in declaratory suit number 29 of 2021 pending the connected appeal. RFA number 21 of 2025. The case of the appellant is that by impugned judgment and order dated 30/11/2024 and decree dated 9/12/2024, the respondent OP number 1 has been declared as the legal owner of periodic Patta number 501601/10/515 of 2008, and the respondent OP number 2 has been directed to make necessary changes in the periodic Patta of the respondent OP number 1 to correctly reflect the location of the suit land. Stop. Mr. Ricky So and So submits that the trial court, while declaring the periodic patta of the plaintiff in the subject suit land as null and void, relied upon the duty report submitted by the settlement officer, Land Revenue and Settlement Department, Kolasib, by letter dated 16th November, report dated date to 16 November 2022, whereby the said settlement officer he was doubt. Which is that particular word you were showing from here? He said that your thing is not complete or something. Page 90, 90A.
91A, my lord. 90A, yes.
That the NOC obtained is not proper. However, the said report prepared pursuant to the detailment order dated 16/11/2022 issued by the settlement officer to the effect to clarify whether these lands, I belonging to the respondent number 1 and to the applicant, overlaps with each other or not. The settlement officer had overstepped the scope and ambit of the inquiry, and hence the trial court erred in law in relying upon the said report. Stop. Mr. Johnny So and So, in his usual fairness, submits that since the stay sought by the appellant has nothing to do in his portion of the land, he has received no instructions to oppose the same. Ms. Vansami So and So has also similarly submitted that she has received no instructions to oppose the prayer for stay. Upon hearing the learned counsels for the parties and having perused the detailment order dated 16 November 2022 and the report and the duty report dated 16 November 2022 vis-a-vis the findings of the learned trial court, this court finds the prima facie good grounds of appeal, and accordingly stays the impugned judgment in order dated so and so and pending adjudication of the appeal. I disposed of. Prayer at Paijaba hetu, huh? And in the main, upar namkhini kurpela issue notice formal that extra copies is required to give here.
Lordship, it's already served to us.
It's served.
It's
So issue
already
notice,
received.
and I think the trial court records have to be called for.
Yes, Your Lordship.
So call for the trial court records. Relist after 3 weeks.
For orders, item 18.
Paper book is done.
Lordship, we have received paper book.
Huh? You received?
Yes, my lord.
You have received?
It can be fixed for hearing.
We will fix it for hearing.
Yes,
then.
my lord.
Heard Mr. A.R. Malhotra, learned counsel appearing for the appellant. Also heard Mr. Elvin.
Lalom, Zwala.
Huh?
Yes. Yes.
Elvin or R. Lalram. Huh?
Lalom Zwala.
L. Lalram Zwava. No, that is Elvin Lalram Zwava. Sorry.
Lalom Zwala.
Lalram Zwava.
Lalom.
Lalrom.
Lom. Zwala.
Zwala. Learned counsel appearing for the respondent. It appears that the paper book as directed by this court has already been prepared. Matter is ready for hearing, relist for hearing in the month of February
Yes.
2026, or a date to be fixed by the registry.
Hearing list, item 1.
Your Worship, in this matter, as per the order dated 16th of June 2020, steps were already taken, but there's no service return on respondent 5 and 6.
How come it's fixed for hearing? Which is that order?
16th of June.
Just see, which is that order?
Sixteenth of June. Six- 2020. 2020. That's on the second page. In the second page.
And then just see this, whether
The second page.
R5 and 6. So what is to be done?
We can take
Fresh steps.
Dusty service.
Okay. It appears that those steps was taken upon respondent numbers 5 and 6 in upon notice being issued by this court on 16/6/2020. However, there is no office note recording completion of service or as regards the status of the service in respect of the aforesaid respondents. Mr. A.R. Malhotra, Learned Counsel for the appellant, submits that he may be allowed to take fresh steps by dusty mode in respect of respondent numbers 5 and 6. Prayer is allowed. Repost after 2 weeks on a date to be fixed by the registry in the order column.
I'm on that.
The council's there. They are there. It's already one. Who's there? Okay. We'll resume at 2 then. Mr. Lalramanga, you are for that item 2.
Item 2, yes, my lord.
So we'll resume at 2.
Yes, your lordship.
Hearing list item 2.
Looks like everybody else have left.
Yes, Your
Huh?
Lordship.
Mr.
Yes.
Lalram Enga
Yes.
and Miss Linda.
Yes, my lord. May it please Your Lordship.
Yes.
Your Lordship, this criminal appeal is filed against the conviction and sentence imposed upon the present appellant, my lord. Present appellants, they were convicted under section 21C NDNPS Act, my lord. They were sentenced to undergo 10 years rigorous imprisonment with rupees 1 lakh fine. And my lord, my grounds for appeal will be, I will raise around 4 grounds, my lord. I'll start with this is regarding seizure of the
Yes.
heroin, 252 grams of heroin kept in 21 soap cases and allegedly seized from the present appellant.
21 soap cases.
21 soap cases, 252 grams.
2 accused.
2 accused persons, my lord.
They were traveling in a tourist taxi in the back seat.
Yes, my lord.
They were traveling from where to where?
From Durtlang road towards Bongkon side.
Duklang is coming from Manipur.
Durtlang is exactly, yes, we can say that it is the way from Manipur side.
Correct. That's why I'm
But it
asking.
is within the Aizawl city only, my lord.
But that's coming from the Manipur side.
Yes, yes, my lord.
Can you spell it for me?
Durtlang. Durtlang.
Dutlang.
Durtlang.
To
Bongkon. Bawng.
BAWNG
NG. KAWN.
KAWN.
WN. Yes, Bongkon.
Yes. And because one of the accused have told the police, right?
Yes.
And the police, in fact, inspector number 7, PW 7, the IO.
PW seizing office.
Total PWs are how many?
5 PWs, my lord.
5.
Yes.
IO is?
IO is PW 5.
5.
PW 1 and 2 are seizure witnesses.
PW 1 and 2 are
seizure witnesses.
And the
3 is the
informant.
And also the seizing officer.
Seizing and informant.
Yes, my lord.
Informant and seizing. Yes.
PW4 is the judicial magistrate first class, before whom inventory was done.
JMFC.
JMFC. PW5 case IO.
Now, in short, your submit, perhaps what you want to argue, Mr. Lalramanga, are 2 or 3 points.
Yes.
One, you are trying to say that the search is not in terms of section 50.
Yes.
Right.
But your lordship, I'm sorry to say that although those grounds are mentioned mainly in our appeal petition, but that is not actually correct, to be honest, your lordship, because that is the private, it is the public place.
Correct.
Section 50 may not be
That's
applicable.
what I was thinking.
Yes.
Because it is not from the person.
Exactly.
It is from the vehicle. So
Right.
50 is not attractive.
Not attracted. So my first ground will be what the seizure witnesses had said. They did not see this actual seizure, and there was also another passenger, which is also evident from the
Yes,
position.
for front seat he was sitting.
Yes, and in the back, on the back side also, my lord. No, sorry, your lordship. One driver, another one passenger, and 2 accused
Correct.
persons.
The 2 accused were in the back.
Yes.
And the driver and the other person was in the front.
Yes.
Dekha matile ahiba.
And I will come to with your lordship.
See, now there, because we will go into the evidence.
Yes.
But Mr. Lalremenga, it is not necessary that that other person has to be also brought as a prosecution witness. If there are cogent evidence pointing the guilt towards the 2 accused persons.
I understand.
Now here it appears that the contraband has been seized from these 2 people, from the back seat.
Back seat only.
With them, they were there, and they have also told one of them that yes, I have brought it from Manipur with the help of my co-accused. He's also helped in securing, and we are taking it. This is there. This has been said by the IO. Now, I see, and you see the most important part, there is a presumption against you, Section 35.
I understand.
Correct?
Yes.
So now, it is up to you to rebut it by bringing evidence, by adducing. In your 313, you don't say anything. The prosecution has, undoubted, the prosecution has to also prove beyond reasonable doubt. But what? The foundational facts, they have proved concession. Suppose we take that they have proved the conscious possession. Now it is for you to rebut it,
Yes.
because otherwise that presumption is against you. Now you have not done that. Simply saying that that the other person has not come, that is not fatal. The other cogent evidence this court cannot ignore. I am indicating my
Yes,
mind.
I understand.
So that accordingly we will read the evidence.
Yes.
Ultimately, somebody's right is involved. We shall read. But looks like there is evidence showing the guilt of the accused. It looks like.
My lord, yes, that is true, your lordship. My argument will be in two stages, so to say. The first
Yes.
one, I'll try to convince your lordship by pointing out the evidences that we had also no conscious possession as well. From the evidences of the prosecution witnesses, I'll try to convince your lordship. And if I cannot, my other ground will be, my lord, standing order, which is mandatorily to be followed. Standing order 1 of 80, standing order, I'll take your lordship to this standing order number 1 of 89, which was framed under section as per section 52A of NDNPS.
Standing order?
Standing order 1 of 89. This is how sample has to be taken, how it has to be sent to
Procedures.
the procedures, to send to the FSL. All these were not complied, my lord. So
Have
this
you
is
brought
fatal.
out all that in your evidence in cross-examination?
Cross-examination, not in detail, my lord.
Then
But your lordship,
this is a criminal appeal.
my lord, my humble contention is
This
that
is not a writ petition.
but my lord, this has to be followed by the
Correct, but you have to bring it out in the cross-examination. These are procedural. Whether the procedure is followed, not followed, if you want to show something specific. Otherwise, it will not be fatal. They are anyway standing orders, not statute also.
Third, I have the, I can rely upon the Supreme Court's decision.
It will
also.
depend on the context of that case.
Yes.
Anyway, let's
Let
start
us
with
see,
the
my lord.
reference.
Yes, yes. With the Lord's permission.
You've passed law. You don't look like. Huh? For a second, I was thinking, why a law student is sitting here with a gown and a band? Huh?
He's still young, my lord.
You know, he looks very young.
Yes.
Yes. So which year did you pass? This year. Fresh. What is your name? All right. Tangpuya. Yes.
So, my lord, I'll not come to the FIR and all. Shall I directly come to the evidences of the
Yes,
prosecution witnesses? Page 15, my lord. 1-5.
1-5.
1-5 is PW number 1. She's a witness.
Yes.
Basically, what he said in the examination in chief is, your lordship, one taxi coming from Durtlang side, it was halted and search was conducted, and that
Read.
your lordship, yes. I know the accused persons who were produced before the court today. On the night of 15/8/2018, while I was at Bong Konsolbuk, 4 female excise personnel came and informed us that they awaited one vehicle and requested us to help them since they are female, and in case if they could not stop the said vehicle, and also requested us to witness search and seizure. We then followed the excise personnel, and at the junction of Bongkon, we awaited the suspected vehicle. At around 2:30 a.m., we spotted the suspected vehicle taxi coming from Durtlang Road, and we halted the said vehicle. Inside the taxi, the 2 accused persons were sitting at the back seat. In my presence, the excise personnel conducted search on the bags carried by the 2 accused persons and recovered 21 soap cases containing heroin. Weighman was taken, and it was 252 grams. Packing and sealing was done. They said They seized the said heroin, also arrested the possessors accused Lalzuin ACL and Gin Moon Loon. And I also stood as one of the witnesses and put my signature in the Caesar memo. Exhibit so and so is Caesar memo and arrest. Exhibit P1 is A is my signature. Cross-examination. It is a fact that there were 4 passengers riding in the taxi where the SA was seized. It is a fact that the SA was found inside 2 bags. It is a fact that I do not know who is the owner of the bags where the SA were recovered. It is a fact that the said taxi was proceeded from
But
Durga.
this he have said it in my presence. The excise personnel conducted search on the bags carried by the 2 accused persons and recovered so and so.
Yes.
This he has categorically said in his evidence in chief.
Yes,
And he's an independent witness, right?
Yes, cross-examination para 3, my lord.
Yes, para 3, he does not know who's the
Yes.
owner. Obviously, how will he know?
Yes.
See,
And-
that is why I'm saying the prosecution has proved your possession because it was taken from the back seat from you. You were sitting in the back and the other person. You both. Now, if that is not yours, then that explanation has to come.
Para 8, my lord.
Yes.
Para 8, I may take a lordship
It
here.
is not. It is a
Cross-examination.
fact that I was not present at the time of taking out of the bags. Out of the bags, he may have come down. He may have come down when the bags were taken out of from the taxi.
And para 11 also.
He
it
might
is-
have come in the front.
Yes. However, lordship, para 11 will be.
It is a fact that we were playing carom board at the time of recovery from the bags.
Yes.
That is, at the time of recovery, he must have meant when the bus was stopped because his evidence in chief is very clear.
And para
On the night of so and so, while I was at Bongkon, so and so, 4 female came and informed us that they awaited one vehicle and requested us to help them since they are female and in case if they could not stop the said vehicle and also requested us to witness search and seizure. We then followed the excise personnel and at the junction of Bongkon, we awaited the suspected vehicle. At around 2:30 a.m., we spotted the vehicle taxi coming from Dotlang Road and we halted the said vehicle. Inside the taxi, the 2 so-and-so were sitting at the back seat. In my presence, the excise personnel conducted search on the bags carried by the 2 accused persons and recovered 20 and so. Yes.
However, lordship,
Okay.
para 11 and 12 contradicted
Noted.
the para 11 and 12 of cross-examination contradicted the examination in chief, my lord.
Okay. Then
And-
PW2.
PW2, my lord, examination in chief is more or less the same with the PW1. It may not exactly the same, my lord.
His cross is, he stand in his cross.
Yes, cross-examination, I would like to rely upon para 1 and 3.
There was one passenger, that is okay. And not know the otherwise he is clear. Yes.
And,
Yes.
and PW3 is at page 17, my lord.
He is who?
She is the seizing of officer as well
Informant.
as the informant. May I read, my lord?
Yes, please.
I know the accused persons. On the night of 15/8/2018, I received information from our source that some persons brought heroin from Colosseum, reduced information into writing and submitted to OCANS. After that, me and my party left to intercept the suspected persons. At the PO, I arranged civilian witnesses. Then, along with the civilian witnesses, we awaited the suspected vehicle. Later, at around 2:30 a.m., we spotted one suspected vehicle taxi coming from Durlang Road and we halted the said vehicle. The accused persons, Lazuin ACL and Gin Min Loon, were sitting on the back seat. Since, as per our information, we suspected them for possessing illicit drugs and after obtaining all the mandatory provisions as per law, we conduct search and found one bag rucksack. I asked the accused persons who is the owner of the bag and they claimed that it belongs to them. In presence of witnesses, we conduct search inside the said bag and recovered 21 soap cases containing heroin. Weightment was taken and altogether it was 252 grams. Picking and sealing was done and submitted my report of seizure and arrest to OCNS. Exhibit P1, P6, P7, P8, my lord. These were exhibited. Cross-examination. It is a fact that there were 3 passengers inside the taxi where the essay was recovered. It is a fact that the essay was recovered from the back seat of the taxi where the 2 accused were sitting. It is a fact that the essay was taken out from the bag recovered from the taxi at the spot where the taxi was halted. It is a fact that we requested the Bongkon WMA duty to assist the recovery of the essay. It is a fact that the weightment, packing and sealing of the essay was conducted at Bongkon WMA Zolbu. It is not a fact that the essay was already recovered from the bag when the 2 seizure witnesses were arrived. It is a fact that prior information was received by excise before conducting search and seizure. It is not a fact that the 2 seizure witnesses did not see the recovery of the essay from the bag. It is not a fact that the 2 accused persons did not claim the ownership of the bag. And para 10, my lord, it is a fact that no case was registered against 1 passenger who was also boarding in the said taxi. It is a fact that the taxi where the essay was recovered, was proceeded from Durtlang and we halted the taxi near Bongkon traffic point. It is a fact that when we asked for the assistance of Bongkon WMA duty, all the excise personnel were female excise personnel. It is not a fact that I deposed falsely before the court today. So this para 10 of the cross-examination, my lord, what I would like to point out is that the 1 passenger was not identified and he was not booked in the case also, my lord. And this was admitted by the PW3.
Yes.
And PW4, your lordship. This is JMFC. On 16/8/2018, I received an endorsement from CJM Aizawl to certify the correctness of inventory photographs and drawing of samples of seized illicit drugs in connection with excise case number so and so, so and so. On the same day, SI Silal ANS ENN made an inventory of seized articles before me, and the report of inventory of SAR as follows: name of drugs heroin quantity 252 grams, mode of packing kept in 21 numbers of soap cases, country of origin Myanmar. After comparing the inventory prepared by SI CAB and the SA produced before me, I certified the inventory of SA are true and correct and put my signature. Samples of the SA were drawn from each of the soap cases in my presence. 2 photographs of the SA were taken before me and put my signature. Exhibit P2 is application for correctness of inventory photographs and drawing of samples. Exhibit P2A is my signature. Exhibit P3 is inventory of SA. Exhibit P3A is my signature. Exhibit so and so are list of samples drawn. Exhibit so and so are my signatures. Exhibit P5 is the photographs of SA. Exhibit P7A is my signature. Cross-examination. It is a fact that the 2 seizure witnesses were not brought before me at the time of conducting inventory of the goods seized. It is not a fact weightment of the SA was not conducted before me. It is a fact that SA was not destroyed in my presence. It is a fact that the inventory of SA was prepared on the same day when I was endorsed to do the same. It is not a fact that the SA was not properly sealed when it was produced before me. It is not a fact that the SA was not produced by the SI of excise. It is not a fact that I am deposing falsely in the court today. And the last
PW4 is who?
PW4.
At page 18, he is the
18 PW4
he is the JMFC.
JMFC, before whom inventory was done.
And 5 is
5 is the case IO, my lord. This is the last deposition. May I read, my lord? I know the accused persons. On 15/8/2018 at around 11:30 p.m., SI Lalha Moi received an information from her source stated that some persons bring heroin from Kolasip to Aizawl. In pursuance of the report, the cited officer and party went to Bongkon for interception of the reported persons and also invited reliable persons from Bongkon locality for witnesses. After waiting for some time, the suspected persons were arrived at Bongkon with a hired taxi. SI Lalha Moi then conducted search and recovered 21 numbers of soap cases containing heroin kept in a black colored rucksack. Weighing of the cited heroin was taken at Bongkon. It weighs 252 grams and the cited officer seized the same and also arrested its possessors, Lalzuin Asial and Gin Min Loon, at 16/8/2018 at 2:35 a.m. Report of seizure and arrest is submitted to OCANS. Case is registered and the same is endorsed to me for further investigation. During my investigation, I examined the accused persons. The accused, Lazuin ACL, stated that on the month of August, he contacted one drug peddler who wants to buy some large quantity of heroin, and further stated that he already knew such a person who possesses large quantity of heroin from Manipur, known as Kimi of Jeribam, and ordered heroin from her. On 15/8/2018, he contacted the said Kimi, and the said Kimi told him to meet him at Silchar. He immediately went to Silchar and met Kimi with one person, namely Gin Minlun from Manipur. He and the said Gin Minlun proceeds from Silchar towards Aizawl, and also stated that they were arrested with the SA at Bongkon before they reached their destination. The accused Gin Minlun stated that while visiting Jeribam, Manipur on 15/8/2018 morning, Kimi of Jeribam asking for transporting some heroin to earn some money and accepted. He himself and Kimi went to Silchar with the seized heroin and met accused Lazuin ACL. Then Lazuin ACL and Gin Minlun proceeds towards from Silchar to Aizawl, and they were arrested before reaching their destination. I also examined the SW seizure witnesses and SO seizing officer. Seizure witnesses stated that they were invited by female officer of excise and narcotics and told them about that they had suspected persons who were coming from Kolasip, and also told them that they had a strong suspicion to possess some quantity of heroin. Regarding the said Kimi of Jeribam, I cannot confirm that the said Kimi exists or not, and I cannot also find her contact number. I also cannot go to Jeribam, Manipur to prove whether the said Kimis exist or not, as the place is out of my jurisdiction. During my investigation, I also done inventory of the essay, drawing samples and photographs of the essay before the Honorable Court of Srimati Lalriyat Pui JMFC, Aizawl, and I also sent samples of the essay to FSL for chemical analysis. Result of the FSL found and the essay were found to be heroin. The purity of each about 72% WW at the time of examination. From collection of my investigation, I find a prima facie case under Section 21C of NDNPS Act against the accused Lazuin ACL for possession of 252 grams of heroin, which violates Section 8C of the same Act, and I charge him accordingly. I also find prima facie case under Section 29, read with 21C of NDNPS Act against accused Gin Minlun for abetting an offense in this instant case, and I then charge him accordingly for violation of Section 29 of the same Act. I then submit complaint sheet against the accused persons for ends of justice, and exhibits were done. And cross-examination, my lord, page 20. It is a fact that I recorded the statements of the accused persons, seizure witnesses, and seizing officer. It is a fact that I sent the samples to
Yes.
the FSL,
Seen it. What is there now?
my lord.
Oh.
So, and your lordship, here, cross-examination, although questions were asked, he said that samples were sent to the FSL examination for
Yes,
examination.
It is a fact that I send the samples. I received back the FSL through OC so and so, and the result shows that the assay were found to be heroin. What is wrong in that? It is a fact that the total quantity is 252 grams.
Yes,
As
my
per
lord.
the statements recorded by me, so and so stated that essay was brought by him from Manipur, and his co-accused assisted him. As per the statement of Caesar witnesses recorded by me, the so and so stated that they were present. He said everything.
Yes, my lord, my humble contention is that it is the prosecution who has to prove
They
beyond
prove-
reasonable
They are
doubt.
going to prove the foundation facts required for 35.
Your lordship, the
They just have
prosecution,
to prove that that possession. They proved it. It is from your possession. You now, if you have to rebut it, you'll have to do it by giving evidence. Is NDPS Act, please, Michael? Can we have the NDPS Act? Oh, sorry, it's there. Sorry. Section 35.
35.
In any prosecution for an offense under this act, which requires a culpable mental state of the accused, the court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. So it is for you to now show that no, it is not you are not carrying, you are not of conscious possession. Prosecution has proved beyond reasonable doubt that it has been recovered from from the back seat in front of Caesar witnesses, and you have stated that yes, I am brought it with the assistance of my co-accused for Manipur, and this car is also coming from that side only. So all the foundational facts, they have proved it. There is no doubt.
Subsection 2 says, my lord, for the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond
Correct.
reasonable doubt.
So that is what I'm saying. I didn't use the word beyond reasonable, preponderance of probability.
Yes, I understand.
I agree with you that to prove a fact for the purpose of 35, the prosecution has to prove it beyond reasonable.
Yes.
But in this case, this court is satisfied that they have, and the trial court has correctly recorded a finding to that effect. This court doesn't find any erroneous or perversity in the findings of the trial court
My lord, one of the...
as far evidence is concerned.
Yes.
And 313, what have you done in 313?
313, my lord, yes. 313 is at page 4 to 6, my lord, of the paper book.
Yes.
The first question is, my lord, it is in evident that on the night of so and so, you boarded on taxi coming down from Durtang Road. Yes, it is true, but there are another 2 passengers, and one is my co-accused, Gin Min Loon, but I do not know the other passenger. Question number 2 is, it is in evidence that the said taxi was halted by excise personnel in Bongkon Junction. Answer is no, it is not true. Though our taxi is halted by the accused personnel, but not at junction of Bongkon, but near Durtlang later. Question number 3 is, it is in evidence that when the excise personnel halted your taxi, you and co-accused, this part is missing, my lord.
Yes.
This part is missing, but let me read this accused number 2, appellant number 2, my lord. Question number 1 and 2 is the same, the way he answered. Question number 3, page 5, my lord. It is evidence that the excise personnel took you to Bongkon Zolbuk. They recovered 21 short cases of heroin from your carried bag. What do you have to say? The answer is no, it is not true. We also claimed before the excise personnel that bags did not belong to us.
Merely
Hence,
saying
I
that
did
is
not
not
aware.
sufficient. Do you have anything more to say? No, you didn't adduce any evidence. You have simply said, no, it is not true. We also claimed before the excise personnel that the bags did not belong to us. Hence, I did not aware the content of the said bags.
He denied.
That's not sufficient. That's a bold denial.
And despite that, your lordship, PW number 1, one of the Caesar witnesses, had admittedly stated that, my lord, while he was playing carom board, Caesar was done and he was not witnessing.
But did PW2 have said?
PW2,
We go by PW2.
although he
PW2,
denied,
nothing is
my lord.
wrong.
Although he denied, but he also stated there is also another 1%.
That is okay.
So it was, my main point is that regarding this Caesar, my lord, my main point is that these seized articles were not seized from the possession of the accused persons. It was seized from the backseat of the taxi. And it could be presumed that there are another passenger also, the driver including another passenger. And that could, that seized article could belong to the other passenger also.
Okay.
So that is my first point.
All right.
And if, I don't know whether I could convince your lordship, and I'll come to the next point, my lord. Regarding clear violation of the standing order.
Yes.
I brought this standing order to your lordship, my lord.
These are not exhibited before the trial court.
Yes, my lord, because this is the first page, my lord. The first page says that this has been framed under section 52A. This is the procedure for how to dispose of and samples to be taken. This standing order 1 of 89. It is applicable in the present case because after 2023, I think there are other new rules. So, my lord, the page 2, para 2.1, 2.2, my lord. I'll start from 2.2. I'll read all the relevant parts only. 2.2 says, my lord, has your lordship got it? My lord?
Yes.
All the packages, containers shall be serially numbered and kept in lots for sampling. Samples from the narcotic drugs and psychotropic substances seized shall be drawn on the spot of recovery in duplicate in the presence of search witnesses panchas and the person from whose possession the drug is recovered, and a mention to file to this effect should invariably be made in the panchnama drawn on the spot. And 2.3 says.
But where have you brought this in the cross-examination?
But my lord, this has to be followed by the prosecution.
But why should we presume that this has not been done?
My lord,
Mr. Lalremengo, why should we presume that this has not been done?
My lord, it is clear from the paper book itself, from the record.
What has not been done?
This one, 2.3, my lord.
2.3
of the standing order.
Quantity to be
Yes.
drawn in each sample for chemical test shall not be less than 5 grams in respect of all so and so. But you have not asked these questions.
But my lord, evidence.
What is that Supreme Court decision you want to rely on this for? Let me see that decision.
Yes. The first one is, my lord.
It better be on this point, huh, Mr. Lalremenga?
It is, the Supreme Court is also very clear, my lord.
Let me see.
Number 1 is 2008,
Give
volume
me.
16, SCC. 2008, volume 16, SCC 417. Para 89 and 91, my lord.
Para
89 and 91.
'89.
Yes, 89.
Yes.
Page 461.
Yes.
May I read, my lord?
Yes.
Guidelines issued should not only be substantially complied with, but also in a case involving penal proceeding, vis-a-vis departmental proceeding, rigors of such guidelines may be insisted upon. Another important factor which must be borne in mind is as to whether such directions have been issued in terms of the provisions of the statute or not. When directions are issued by an authority having the legal sanction granted, therefore, it becomes obligatory on the part of the subordinate authorities to comply therewith. Para 91. The logical corollary of these discussions is that the guidelines which as those present in the standing order cannot be blatantly flouted, and substantial compliance therewith must be insisted upon for so that sanctity of physical evidence in such cases remains intact. Clearly, there has been no substantial compliance with these guidelines by the investigating authority, which leads to drawing of an adverse inference against them, to the effect that had such evidence been produced, the same would have gone against the prosecution.
The context is different. I don't have any, you see, it is, what you are arguing is not disputed, that position of law. It has to be rigorously followed, no doubt about it.
Yes.
But here, what you want to show that this is not done, therefore it's fatal, that would
Yes.
be difficult for this court to accept, because we may only say that it is insisted. If there are guidelines, you follow. Now, if something specific has not done, how far that is fatal to the prosecution case, this would also depend on the facts of each case. Now, in your case, during cross-examination, not a single whisper to any of these questions. If this has been done like this, if that has been done, this has never been brought out in the cross. And we find that there are sufficient evidence linking you, that conscious possession, that presumption. You have not rebutted it.
My lord,
Nothing remains thereafter.
My lord, I understand what your lordship has said. Despite that, your lordship, another point to be taken into account is that whether this SA is heroin whether it is actually heroin or not. In order to have the test,
The FSL
sending,
report?
but there is no link, my lord. I'll come to that point also. Link is not there. Sending of the FSL and sample has to be drawn correctly, my lord.
In the cross, you ask these questions. It is a fact that I send the samples to FSL for expert examination. I receive back the FSL report through the OC so and so, and the result shows that the assay were found to be heroin with a purity of 72 so and so. It is a fact that the total quantity of the assay was so and so. What is there, Mr.
While saying this, my lord,
You are trying your best, but Mr. Lalramanga, at the end of the day, we are bound by the what is there on record. You cannot improve now.
but your lordship,
You cannot take back the matter to the trial court. You're not on. You're not at the examination stage.
my lord, from the
Now, we can only appreciate and reappreciate the evidence. Evidence is clearly against you.
your lordship, may I take your lordship to page 76, my lord?
Yes, why not?
Because what I'm trying to show your lordship is that there is no link evidence showing that it was actually sent to the FSL.
That's very weak points, Mr. Lalramanga. Sorry.
My lord, I may start from page 76. I'll not read the whole content.
I have 76.
This is the inventory application, my lord.
Yes.
And page 77.
The
is the-
inventory is proved by the CJM.
Yes.
By the JMFC.
Yes, my lord, 77 is the taking of the samples starting from 77. 78 will show that sample were taken, but the quantity is not given here. While the standing order 2.3 says that 5 grams each from each of the container, my lord.
Okay.
And thereafter, my lord, page 88 is the FSL report.
Page?
88.
Yes.
And if we look at the description of exhibits in the middle of the page, my lord,
Yes.
the quantity, the weight sample taken is 57 mg and another one is 72, 46, 90, 40, so and so.
Okay.
These are very less, no 5 grams each, my lord.
Okay.
And this has to be strictly complied with, standing order. And my lord, if
It has to be, shall not be less than 5 grams.
yes, shall not be-
These are more than 5 grams.
no, my lord, these are mg only, 57 mg
So
only.
much less.
Much less.
So then what is wrong?
Then it is not complied with, my lord.
Or not less?
Yes, not less. Standing order is blatantly, my lord, it is violated.
Yes.
And my lord,
You have any decision which says that in such matters the entire prosecution case becomes fatal? Because that decision is not helping you much. It says that it should be insisted upon. It doesn't say that the prosecution case is fatal. You want to say that not sending more than 5 grams, the seizure is vitiated. That is what you want to say.
yes.
So
And
basically, in short, the prosecution case becomes fatal.
In that case, my lord, 2023 SCC online.
Sure.
Your lordship, with apologies, this I misplaced my citation, my own copy.
No problem.
There is para 7 and 8. There is Mangilal versus State of Madhya Pradesh. It says
I
that
have it.
yes, standing order has to be followed.
7 and
7 and 8, my lord.
See, para 8, that's why I'm trying to tell you. A court should be satisfied with such compliance when deciding the case. The onus is entirely on the prosecution in a given case to satisfy the court when such an issue arises for consideration. The issue never arised. You never raised this issue. You never raised it. Production of seized material is a factor to establish seizure followed by recovery. One has to remember that the provisions of the NDPS Act are both stringent and rigorous, and therefore the burden heavily lies on the prosecution. Non-production of a physical evidence would lead to a negative inference within the meaning of so and so. The procedure contemplated through the notification has an element of fair play, such as the deposit of the seal numbering so and so and keeping them in so and so.
That is also, my lord, what I would like to emphasize. Because, my lord, here, page 88 of the paper book, this is the FSL report, but there is no link evidence which says that it was actually received by, there is no sending, there is no receipt or the seal which was mentioned, which corroborates sending of the samples to the FSL, my lord. This report is not sufficient. The forwarding letter has to be there, my lord. It is not there in the present case.
This was in a context where the samples were not produced.
Yes.
Physical evidence was lacking.
Yes. In the present case also, my lord, nothing was mentioned about production of the assay.
It is there.
And I have another citation, my
The
lord.
Caesar list is proved. Exhibit P1 is Caesar and so is my signature.
Caesar,
PW1, exhibit P1 Caesar and so. Then 4 is the inventory. This is, he's given seized articles before, on the day made the inventory of seized article before me, and the report of inventory are as follows: quantity 21 numbers of so and so.
But the
Samples were drawn, 2 photographs were taken. So and so is my signature, all the list of samples drawn are my signatures. Photographs of Caesar search article, it is there.
but no, the essay was not produced.
It's all there. It is a fact that the essay was not destroyed in my presence. It is not a fact.
It was
so-and-so
not destroyed.
conducted. I was endorsed, properly sealed when it was produced before me. Yes. Anything else?
Yes, my lord. Now my other citation is 2009, volume 12, SCC 161. Para 36 and 37, my lord.
This is for what point?
This is regarding sample drawn. The quantity is less, my lord. Not compliance with standing order.
Paragraph?
36 and 37.
But here, the main, it was only part of it because that was another aspect. In that case, mainly because that conviction, that confession was not corroborated. Therefore, it cannot be forming a basis for conviction.
There is nothing to show that adequate quantity from each bag had been taken.
These are other infirmities which have been noted.
Page para 36 is
I
relevant.
read.
Mm.
There are other. There is another aspect of the matter. It starts with. There's nothing to show that adequate quantity was taken. It was a requirement in law.
Yes.
But you see, in your case, this is the only ground of you are seeking. The prosecution case has been dented, only because of sending less quantity.
Yes. It has to be 5
So,
grams.
that only for that non-compliance, you want to say the prosecution case is dented,
Yes.
which is I am finding difficult to accept
And another point
in
is,
view of the cogent evidence.
but my lord, there is no link. Sending the actual sending of the to the FSL, there is no link evidence. There is no forwarding letter, and the receipt saying that from the FSL, this seal, it is sealed like
How
seal.
can I ignore the cross-examination of the inventory, the JMFC?
No, I'm not talking about inventory, my lord. I'm
No, sorry, the
FSL sending sending to
Correct.
the FSL.
correct.
And
that
there is,
part.
my
There
lord,
is already that has come in cross. And he says that these samples are, it is there.
my lord, even in the absence in the
Anyway, let's not
cross-examination.
repeat the
Yes.
arguments. Anything else?
Yes, my lord, my other citation, I would like to try to convince your lordship, there is no
Hmm.
link evidence, sample seal not matched. This is 2005 volume
But that
3.
is not match. Here that is not coming. The IO has said, the FSL clearly said the seized articles are heroin.
However, your lordship, there is no receiving evidence to indicate that it was received by the FSL also, my lord.
IO has given the evidence. In that case, perhaps nothing is there.
And
These are very technical. You are arguing a criminal matter. That's very
but your lordship,
technical.
this non-compliance of mandatory provisions of law, it is fatal, my
See,
lord,
no,
to the
that
prosecution.
has to be so strong that it goes to the root of the whole case. These are not taking away the root.
Your lordship, but the citations in which I am relying upon, these are quite relevant to my case as well, my lord. Anyway, my lord, I may take your lordship to this another citation, 2005 volume 3 SCC, page 59. Para 3 only, my lord.
Yes.
This is regarding link evidence adduced by the
Michael?
prosecution.
Can you open one window?
May I read para 3, my lord?
Yes.
We have perused the judgment of the High Court. Apart from other reasons recorded by the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactory. In the first instance, though the seized articles are said to have been kept in the Malkhana on 25/1995, the Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by PW6 on 5/6/1995. We further find that no sample of seal was sent along with the sample to the excise laboratory, Jodhpur, for the purpose of comparing with the seal appearing on the sample bottles. Therefore, there is no evidence to prove satisfactorily that the seals were found in fact the same seals as were put on the sample bottles immediately after seizure of the contraband. Those loopholes in the prosecution case have led the High Court to acquit the respondent. In the present case also, my lord, there is no evidence at all to say that the samples were actually received, whether the seals, the envelopes where the samples were kept,
Okay.
whether it was sealed or not.
Okay.
It was not, there is no link evidence, my lord. And lastly, my lord, uh, 1999 volume 6 SCC 172. Para,
Yes.
para 28 only, my lord. I'll not read the whole content, my lord. What I'm trying to say here is that the severe the punishment, greater has to be the care taken to see that all safeguards are strictly followed as
Paragraph?
28. If the punishment is severe, my lord, has to be taken to see that all the provisions made by the statute are strictly complied with.
Okay.
And my last point will be, my lord, I thought I should have said at the initial stage.
Yeah.
Page 2 is the church head.
That he has not relied, no? Noor Aga, have you relied?
Yes, my lord.
Paragraph 91. Okay, standing orders. Okay. Yes.
Page 2 of the paper book. I thought I should have said at the initial stage, but
Yes.
this is regarding church head, church
Yes.
frame. And I'll come directly to the bottom of the page. It is in handwritten. This accused, this appellant number 1, he pleaded guilty by saying Kimi of Manipur asked him to transport the seized article for a reward of so and so. And page 3 is also another, that appellant number 2.
Yes.
He also pleaded guilty. And that should not be overlooked. Despite this, my lord, page 33 is the judgment and order, impugned judgment order 33.
They pleaded guilty.
They pleaded guilty. It is written like this.
Guilty by saying?
By saying that Kimi of Manipur asked him to transport the seized article for a reward of rupees 10,000.
So they admitted it's a confession.
That is what I'm trying to point out, my
So
lord.
what happens then?
Page 33. May I take your lordship to page 33 again? There is a contradiction.
Yes.
Para 3 of the impugned judgment, my lord. It says that
Not guilty.
not guilty. And
But Miss Linda, they seems to have pleaded guilty, no? Then?
my lord, while saying this, assuming for a moment that they pleaded guilty, although that is contradicted by the impugned judgment, I have one citation. This is the judgment of this honorable court.
Yes.
My lord, I'm sorry that I have given a copy to which I have highlighted, my lord.
Oh, it's okay.
Para 21, my lord.
Yeah.
It's,
It will only benefit the court
my lord, para
to
21.
the prejudice of Miss Linda.
Yes, that is what.
Yes.
Here also in this case, the accused person pleaded guilty, my lord. Para 21 says, what emerges from the above discussion, held as a whole, is that majority of the high courts are of the view that the court should not ordinarily act upon the plea of guilty of the accused in serious offences such as murder, and that in such cases the decision shall be rendered after the
So
entire
that is the
evidence.
position. So
Yes.
even if the trial court has said not guilty,
Yes.
ultimately it has to take the evidence and decide.
Yes, yes, that
So
is
which has been done. So basically it's not fatal. This court
Yes.
will,
So what I'm trying to say is that despite the alleged plea of guilt, then we have to see the evidence as well as what mandatory provisions are not complied with.
so ठीक है.
Yes.
Okay.
These are my submissions, Your Lordship. With this, I'm praying Your Lordship that they may be acquitted.
All right, Mr. Laramanga.
Yes.
Yes, Miss Linda.
First of all, my lord friend has pointed out already they have pleaded guilty during framing of charge.
You have a list of the books, case laws you have cited, na?
Yes, my lord.
Can you put it in a piece of paper and give it to me?
Yes, my lord, I have already put with the benches.
Made a list.
But my lord, the last one, this regarding plea
That
of
also you put. Just give it to him once.
Yes,
Mr. Lalrema, against that decision, just put that heading. Plea of guilty,
Yes.
mandatory section. Just put a key
I'll do
word to it. It'll be easier for me.
Yes.
Yes, Miss Linda.
Yes, my lord. At page 2, my lord, during framing of charge, the two appellants, they have already pleaded guilty. And not only pleaded guilty, they have also said in their own words, my lord, Kimbi of Manipur asked them to transport the seized article for a reward of rupees 10,000. So, my lord, they have already accepted that possession is in their hands, my lord.
But this is not evidence.
This is not evidence, but this is the basis, my lord, from the beginning.
No, but where has it come? Your trial court itself have.
Trial court, my lord.
The trial court have said not pleaded guilty.
This appears to be a typo, my lord.
Whatever.
Because
So for us, page number 2 is of no consequence. Your trial court have said not pleaded guilty.
but my lord,
Right.
on what basis, my lord? The
And,
trial
and
court has
even
stated
and even assuming for a
because it's on
moment,
record.
Miss Linda, even if assuming for a moment that they have pleaded guilty,
Yes.
even in that situation, the court has to go because the
Yes,
henious
yes.
crime. It is a
Evidence has to
serious
go.
crime, so it has to be ultimately
that is
decided
true.
on evidence. Now, I find that there is evidence. However, he's been insisting very vehemently that the seizure has not been done in terms of your standing orders.
Yes.
The requisite grams
Grams amount.
has not been weighed, for which the entire weighing of the samples is vitiated. So how far all that makes the investigation fatal, the prosecution case dented,
My lord,
dented,
with
sorry.
regard to that standing order, my lord, the order is there, my lord, no doubt.
Huh.
But the FSL has clearly given their findings, my lord. Whether 5 grams was taken or not, my lord.
No, that
The
page is
result
there.
is that it was found to be heroin. and a
Yes,
purity
but
of
then,
about
but then,
72%.
if you come to page 88, description of exhibits,
Yes,
57 mg, 72 mg, 40 mg.
that is true, my lord.
So
This
it shows gross contravention of your standing orders.
Yes, my lord.
There are
There is some
decisions.
contravention, my lord.
Now there are
This
decisions.
cannot be fatal to the case
So
because
that's
the
why I'm
report is
asking.
there, my lord.
You see, that's why I'm asking because the apex court decisions that are relied by Mr.
Yes, I have
Lalramanga.
seen it, my lord.
So do you have anything to counter that?
Yes, my lord. In that regard, my lord, the decision which he has produced, my lord, that 2009-12 SCC, my lord, I'd like to point out that this contravention of the standing order is not the sole basis for acquittal. In fact, my lord, it's an acquittal order because of some other factors. And this acquittal order was appealed by the state. So the case is totally different, my lord. There has not been a single Supreme Court judgment where, because of violation of this standing order, a person should be acquitted. So, my lord, this is not the sole basis.
All right.
That is what I've seen.
Call Decca. You want to reply? I'm calling for the stenographer. I'll dictate in court. I have this bad habit of dictating in court. I'm saying bad because sometimes, yeah, you both will now have to also bear with me, yeah?
It's okay, ma'am.
But it's easier. You see, if you dictate it in the court, it's become very easy because I have the benefit of you both. So, while, recording your submissions, while recording the facts, you have that liberty to, correct if something, because we all are human. So I like doing it in that manner. And as it is, I think this is the last matter. I don't see anybody waiting in the courtroom for today, and we are only at 3. So we have a good time to finish it off. take your seat, and once you complete, you give it to Michael. Heard Mr. Lal Ramanga, learned counsel, appearing for the appellant. Also heard MS Linda, learned APP for the state respondent. This appeal is directed against the judgment and order dated 19/7/2022 passed by the judge special court, it says. Or special judge or judge? By the learned judge special court NDNPS Act 1985 Aizawl, Mizoram in SR number 285 of 2018, reference excise and narcotic case number N-172 of 2018, whereby the appellants were convicted for offences punishable under section 21C of NDPS Act so and so, and sentenced thereof to undergo by order dated by impugned sentence order dated 27/2022 to undergo 10 years rigorous imprisonment with a fine of rupees 1 lakh and failure to pay the fine another rigorous imprisonment for 1 year. Stop. The brief facts of the prosecution case are that on the night of 15/8/2018, at around 11:30 p.m., PW5 SI Lalnang Maui received an information from her source that some persons would bring heroin from Kolasip, Mizoram. In pursuance to such report, a team party went to Bongkon, Aizawl, to intercept the suspected persons. After waiting for some time, the suspected persons reached Bongkon in a taxi. They conducted search in the presence of the witnesses and recovered 21 numbers of soap cases containing heroin kept in black rucksack. The seized articles were seized at 2:30 a.m. on 16/8/2018, and the weight of the seized article was taken, which is 252 grams of heroin. Accordingly, a case was registered against the appellants. Thereafter, the appellants were arrested on 16/8/2018. And thereafter, the appellants were arrested on so and so, and accordingly, a complaint sheet was submitted by the investigating officer before the special court so and so against the appellants by forwarding letter dated 2/10/18. It appears Nokoba, upon appearance and charge sheet, upon appearance, the learned judge Special Court NDPS framed charge under Section 21C of NDPS Act 1985 against the appellants upon pleading guilty. Stop. During trial, prosecution examined 5 prosecution's witnesses, namely so and so Ekhini Paba, page 5 or paragraph 4 of the appeal memo. Upon completion of the prosecution evidence, all incriminating circumstances were put to the appellants accused under Section 313, wherein the accused appellants denied the allegations made against them. Thereafter, the trial court passed the impugned judgment in order of conviction, situated thus the present appeal. Mr. So-and-so, learned counsel appearing for the petitioner, for the appellant, submits that the driver and the front seat passenger of the tourist taxi, from which the seized articles have been allegedly recovered, both being material witnesses, were neither prosecuted nor examined. He further submits that the search and seizure He further submits that the seizure was in gross violation of the standing orders dated
One of 89.
dated, where do you get the date?
Date is 22/11/1989 at the top of the page, right side.
Oh, yes, dated 22/11/1989, framed under Section 52 capital A of so and so Act. He further submits that there is no direct evidence connecting the accused appellants with the alleged contraband. He further submits that the prosecution has failed to discharge its burden under the stringent provisions of the NDPS Act. So and so. In support of the aforesaid submissions, he relies upon the following decisions: 1, 2, 3, 4, 5, 6. Per contra, MS Linda so and so submits that the case of prosecution is on the basis of the specific information received, upon which a raid was done in the subject tourist taxi, from where the seized articles were recovered from the possession of the accused appellants sitting in the back seat of the said vehicle in front of 2 independent witnesses. The prosecution, having proved the foundational facts for drawing presumption under Section 35 of the NDPS Act, the defense having failed to rebut the same, the impugned judgment and conviction of the trial court warrants no interference from this court. I have given my prudent consideration to the arguments made by the learned counsels appearing for both the parties, and have perused the material available on record. I have also duly considered the case law cited at the bar. The case of the prosecution is that on receipt of prior and specific information, a raiding team intercepted a tourist taxi at the relevant place and time. The accused appellants were seated in the rear seat of the said vehicle. Upon search of the vehicle, the police party, in the presence of two independent witnesses, PW 1 and 2, recovered contraband substances from the baggage from the bag produced by the accused appellants. PW PW5, the investigating officer, deposed that after receiving the information as regards transportation of contraband articles in a hired taxi from Kolasip to Aizawl, upon formation of a team along with two reliable persons from the locality in question, intercepted the said vehicle, which arrived at Bongkon, and upon a search being conducted in the presence of PW 1 and 2, they recovered 21 numbers of soap cases containing heroin kept in a black-colored rucksack. He further deposed that weighing of the cited heroin was taken at Bongkon and it weighed 252 grams, and the cited officer and he further seized the same and also arrested the accused appellants on that date itself. On 16/8/2018. He further deposed that report of seizure and arrest was submitted to OC ANS and accordingly a case was registered and the same was endorsed to him for further investigation. He further deposed that during his investigation, he examined the accused appellants and the accused appellant number, Laljung Lisai is number?
Number 1, my lord.
Number 1 stated that on the month of August, he contacted one drug peddler who wants to buy some large quantity of heroin and further stated that he already knew such a party who possesses large quantity of heroin from Manipur known as Kimi of Jeribam and ordered heroin from her. He further deposed that the accused appellant number 1 further stated to him that on 15/8/18 he contacted the said Kimi and she told him to meet him at Silchar, and accordingly he went there and met her with co-accused appellant number 2 from Manipur. Stop. He further stated to PW5 that he and accused appellant number 2 proceeded towards from Silchar towards Aizawl and also stated that they were arrested with the seized article at Bongkon before they reached their destination. He further stated that accused appellant number 2 he further deposed that accused appellant number 2 similarly stated that while visiting Jeribam, Manipur on 15/8/18 morning, Kimi of Jeribam asked for transporting some heroin to earn some money, and accordingly he accepted, and then he along with her went to Silchar with the seized heroin, where they met accused appellant number 1. He further stated that then along with accused appellant number 1, they proceeded towards from Silchar to Aizawl, and they were arrested before reaching their destination. PW 5 further deposed that he examined the seizure witnesses and the seizing officer. He further deposed that regarding Kimi, he could not confirm if she exists or not, as he could not find her contact number. And since the place is out of his jurisdiction, he could not go there to find about her. He further deposed that during investigation, he had done inventory of the seized article, drawing samples and photographs of the seized article before the PW4, and also sent samples of the seized article to FSL for chemical analysis, and that the result of the FSL found the seized articles to be heroin, the purity of each being about 72% W/W at the time of examination. He accordingly, upon completion of his investigation, found prima facie case under Section 21C of NDPS Act against the accused appellants, and accordingly charged them and submitted the charge sheet. He further exhibited the charge seizure and arrest memo, the application for correctness of inventory photographs and drawing of samples, inventory of seized article, list of samples drawn, photographs of assay, information report, reasons for search, report of seizure and arrest, report of FSL, and the complaint sheet as Exhibit P1, P2, P3, P4, P5, P6, P7, P8, P9, and P10 respectively. During cross, he clarified that he recorded the statement of the two accused persons, seizure witnesses, and seizing officer. He further clarified that he sent samples to the FSL for expert examination. He further clarified that he received back the FSL report through the OC-ANS, and the result shows the seized article to be heroin with a purity of 72% WW each. He further clarified that the total quantity of the assay was 252 grams of heroin. He further clarified that as per statement recorded by him, the accused appellant number 2 stated that the seized article was brought by him from Manipur, and his co-accused appellant number 1 assisted him from Silchar to Aizawl. He further clarified that as per the statements of the seizure witnesses recorded by him, the two seizure witnesses stated that they were present at the time of recovery, conducting weighment, packing, and sealing of the seized articles. PW 1 and 2 are the Caesar witnesses who supported the testimony of PW 5 and deposed before the court that on the night of 15/8/18, while they were at Bongkon, 4 female excise personnel came and informed them that they awaited one vehicle and requested them to help them since they are female, and in case if they could not stop the said vehicle, and also requested them to witness search and seizure. They further deposed that they agreed to witness the search. They found 2 accused persons, the 2 accused appellants sitting at the rear seat of the said tourist taxi, and in their presence, the officers conducted search on the bags carried by them and recovered 21 soap cases containing heroin. They further deposed that weighment was taken and it was 252 grams. They further deposed that packing and sealing was done. They further deposed that they seized the said heroin and arrested the possessors, and they stood as witnesses in the Caesar memo. During cross-examination, PW1 clarified that he does not know the owner of the following 1, 2, 3, 4, page 18. He further deposed that he drew samples of the seized article from each of the soap cases, not he drew, Lokopa. He further deposed that samples of the seized article were drawn from each of the soap cases in his presence. He further deposed that 2 photographs of the seized article were taken before him and he had put his signatures. He further deposed that Exhibit P2 is application for correctness of inventory photographs and drawing of samples. He further exhibited the inventory of the seized article as Exhibit P3. He further exhibited the list of samples drawn and identified his signatures as Exhibit P4, Exhibit PA, Exhibit 4B, Exhibit P4C, P4D, and P4E respectively, and Exhibit P4 small a, P4 capital A small a, P4 capital B small a, P4CA, P4DA, P4 and P4EA respectively. He further exhibited the photographs of the seized article as Exhibit P5. During cross-examination, he clarified that the 2 Caesar witnesses were not brought before him at the time of conducting inventory of the goods seized. He further clarified that the weighment of the seized article was not conducted before him. He further clarified that the inventory of the seized article was prepared on the same day when he was endorsed to do so. He further denied the suggestion that the seized articles were not properly sealed when it was produced before him. He further denied the suggestion that the seized article was not produced by the SI of Excise. During cross-examination, during 313 statements, the accused appellant, while denying the incriminating circumstances generally, explained that the bags, explained that they also claimed before the excise personnel that the bags did not belong to them. and therefore they were not aware of the content of the said bags. The following issues arises for consideration: whether the seizure is vitiated for want of compliance with the standing order dated 22/11/1989, purported to be framed under section 50 of NDPS Act so and so. 50, na?
Yes.
50 or 52?
T, my lord. But section 50 will not be.
52 capital A.
Yes, 52.
Number 2, whether the non-examination of the driver and front seat passenger undermines the prosecution case. Number 3, whether the prosecution has successfully proved conscious possession of the contraband by the accused appellants. Number 4, whether the statutory presumptions under section 35 and 54 of the NDPS Act so and so apply, and if so, whether the accused appellants have rebutted them. The primary contention advanced before this court is that the accused appellants, that the investigating officer has not drawn up the requisite quantity in each sample for chemical test in terms of the standing orders dated 22/11/1989. Clause 2.3 of the said standing order pertaining to issued under the power conferred by subsection 1 of section 52 capital A of so and so reads as under, quote unquote. It appears that though as per clause 2.3 of the said standing order, the quantity to be drawn each sample for chemical test shall not be less than 5 grams in respect of all narcotic drugs and psychotropic substances. Save in the cases of opium, ganja and charas, where a quantity of 24 grams in each case is required for chemical test, comma, it appears from the description of the exhibits contained in Exhibit P9 that the samples are weighing about 57 mg, 72 mg, 46 mg, 90 mg, 40 mg or so, which are much, much less than the requisite prescribed quantity. There is no quarrel to the proposition that standing orders framed under the provision of the law prescribing the guidelines to be followed in the case of investigations ought to be rigorously followed. However, non-compliance of the same alone may not at all situations be fatal to the prosecution case. It shall depend on the context of each case as what is the non-compliance alleged and what effect does the same has on the credibility of the prosecution case. In the present case, the non-compliance that is urged is as regards drawing less quantity than the prescribed maximum quantity for drawing sample of the seized articles. True that the investigating agency must be insisted to follow the procedures laid down in the standing orders, but non-following of the same in the event there are other evidence to show that the prosecution has proved beyond reasonable doubt the guilt of the accused appellants may not be sufficient to dent the prosecution case so as to make the same fatal, so as to vitiate the entire trial. Now, turning to the testimonies of the prosecution witnesses, it appears that PW5 testimony of the of recovering the contraband seized articles from the possession of the accused appellants is fully corroborated by the two independent seizing witnesses, PW 1 and 2. Their testimony appears to be trustworthy and reliable. Though the defense urged that the failure to examine the front seat passenger is fatal, however, it is settled law that the prosecution is not bound to examine every witness if the evidence on record is otherwise cogent and credible. The testimony of the PW5 investigating officer is consistent, unshaken, and inspires confidence. IO and the raiding officers. PW 3. No contradiction has been established to render their evidence doubtful. Hence, the omission to examine the driver and front seat passenger does not affect the prosecution case. It further appears that the contraband has been recovered from the rear seat area occupied by the appellants. The concept of possession under the NDPS Act encompasses custody and knowledge. The testimony of PW5 that one of the accused appellants admitted procuring the contraband from Manipur with the co-accused further corroborates the recovery. Statements furnished as contemporaneous conduct may be taken into account as corroborative evidence. Hence, it is evident that the prosecution has clearly proved conscious possession. Once possession is established, the presumption under section 35 and 54 arises. Hence, the burden then shifts to the accused appellants to rebut these presumptions on a preponderance of probability. In the present case, except for a bare denial under section 313 CRPC, the accused appellants have offered no explanation whatsoever. I am of the firm view that mere denial is insufficient to rebut this statutory presumption in law. Accordingly, the prosecution has discharged its burden and the presumption remains unrebutted. The chain of custody has been proved through consistent testimony regarding seizure, sealing, sampling, and forwarding. No material defect or tampering has been demonstrated. Minor procedural discrepancies not going to the root does not vitiate the prosecution case. Hence, this court finds no infirmity in the judgment of the conviction passed by the learned special judge. The prosecution has established beyond reasonable doubt that the accused appellants were in conscious possession of the contraband articles recovered from the vehicle. Accordingly, the conviction and sentence are hereby affirmed. Criminal appeal stands dismissed. And are you outside?
No, my lord, we are in jail.
You're in jail. Any pending applications? Anything is there?
No, my lord.
खाली attach jagat. ये तुम्हारे power को बोलो. It we just लिखिंगा. As regards the decision of the apex court in Noor Aga Supra, relied by the appellant, it appears that the apex court has emphasized that guidelines guidelines issued should not only be substantially complied, but also in cases involving penal proceedings, such guidelines ought to be insisted upon. And accordingly has held that standing order ought not be blatantly flouted and substantial compliance must be insisted upon. It further appears that in the said case, the apex court further noted that omission on the part of the prosecution to produce evidence in that case must be linked with a second important piece of physical evidence, that the bulk quantity of heroin allegedly recovered indisputably has also not been produced in court. In that view of the matter, in the aforesaid context, the apex court rendered that decision. The same, however, is not the consequence. Same, however, is not relevant in the instant case. As regards State of Rajasthan versus Gurmail Singh Supra, it appears that the context therein was in a case where no sample of seal along with the sample was sent to excise laboratory for comparing with the seal appearing on sample bottles. And in that situation, it was held that there was no evidence to prove that the seals found were the same as were put on sample bottles immediately after seizure of contraband articles. However, the same is not the case in the context of the present case. In the case of Union of India versus Bal Mukund Supra, it appears that the acquittal was not merely on the ground that adequate quantity from each bag had not been taken, but was one of the factor taken note while acquitting the accused appellant in that matter. The decisions of apex court are contextual and hence the cases relied by so and so are of no consequence in the facts of the present case. Sorry.
Much obliged, madam.
Return TCR. Thank you, Mike. Standing orders, you give it to him. All right.